Colleagues, the next item of business is Stage 3 proceedings on the Animals and Wildlife Penalties, Protections and Powers Scotland Bill. In dealing with the amendments, members should have with them the bill as amended at Stage 2, the marshalled list, the two supplements to the marshalled lists and the grouping of amendments. Just to remind members, the division bell will sound and proceedings will be suspended for 5 minutes following the first division of the afternoon. And the period of voting for that first division will be 30 seconds. Thereafter, there will be a 1 minute division for the first vote after any grouping. And members who wish to speak in the debate on any group should press their request to speak button as soon as I've called that group. Members should now refer to the marshal list, and I call Group 1 on animal welfare offences penalties. Can I call Amendment 32 in the name of Colin Smith in a group on its own? Colin Smith to move and speak to Amendment 32.
Thank you very much, Presiding Officer. Can I begin by declaring an interest as a proud member of the League Against Cruel Sports, the Deputy Convener of the Cross-Party Group on Animal Welfare and Scottish Environment Links MSP, Species Champion for Badgers. Amendment 32 in my name looks to increase the maximum penalties available for offences introduced by secondary legislation under the 2006 Animal Health and Welfare Act. As it stands, the maximum fine for any offences created by secondary legislation under this Act is 6 months imprisonment or a maximum fine of £5,000. However, the bill grants ministers broad regulation-making powers, for example, allowing them to introduce secondary legislation creating offences in order to secure the welfare of animals and relating to the licensing of activities involving animals. These broad powers, which could underpin a range of potentially very serious offences. Offences created using these powers could also involve businesses, some of which may be highly profitable, for example, regulations on the licence of animal breeding. In this context, it's essential that fines can be set high enough to act as a deterrent. My amendment proposes that ministers are able to set penalties of up to 12 months imprisonment or a £40,000 fine for offences made under sections 26, 27 and 28. That is offences relating to any provision for securing welfare, the licensing, etc. of activities involving animals and prohibitions on keeping certain animals. This will provide ministers with the freedom to set appropriate penalties when introducing more serious offences through secondary legislation and will ensure that the financial penalties are adequate where profit is a factor. However, they will still be free to set lower penalties where appropriate, and penalties set through these sections will still receive scrutiny through the regulation-making process. The 2006 Act makes clear that ministers have a statutory duty to consult prior to issuing regulations under these sections, and it must then be approved by Parliament. This amendment reflects the need for higher maximum penalties for animal welfare crimes in order to allow fair and proportionate penalties to be issued, which is one of the key aims of this bill. Having raised the wider issue of penalties during Stage 2, I'm pleased to have been able to work constructively with the Minister to present this amendment, which I think is both sensible and proportionate and will help to future-proof the powers in the 2006 Act to make regulations, including future regulations for the licensing of activities involving animals. Presiding Officer, I therefore am happy to move Amendment 32 in my name. Thank you.
Thank you very much. And I call Finlay Carson to be followed by Liam MacArthur.
Thank you, Presiding Officer. As we know, the overall objective for this bill was to increase the range of sentencing options in relation to animal welfare and wildlife offences. So we support the amendment by Colin Smith, Amendment 32. We believe it's right that anybody who commits an offence under the Animal Health and Welfare Act should receive the highest penalty available, and we support the proposed increase in penalties.
Thank you very much. Liam MacArthur.
Thanks, Presiding Officer. Like in the Carson, at the heart of this bill is a desire to see cruelty towards animals and abuse of their welfare treated more seriously. That requires penalties to be increased, to be brought more in line with the sanctions in place in most other countries in Europe to reflect better the seriousness of the crimes themselves. So I very much welcome Colin Smith's Amendment 32 as a further step in that direction, and the Scottish Liberal Democrats will be supporting it.
Thank you very much. And Minister Marie Gougeon.
Thank you, Presiding Officer. At Stage 2, I fully appreciated the aim of Colin Smith's original amendment and indicated my support there for his intent. So I was more than happy to work with him to provide a suitable alternative. I think it's a very helpful, it's a proportionate measure which will give useful flexibility to develop future animal welfare regulations with appropriate higher maximum penalties. And unlike the original amendment on this subject, it won't prevent the Scottish Government providing for the use of fixed penalty notices or indeed lower maximum penalties for offences in future regulations. So with that, I'm happy to support the amendment.
Thank you very much. Does Mr Smith wish to add anything by way of winding up? Thank you very much. In that case, we move straight to the vote. The question is that Amendment 32 be agreed to. Are we all agreed? Yes. We are agreed. Turning to Group 2, this is on protecting dogs from unnecessary suffering, docking. Can I call Amendment 33 in the name of Mark Ruskell in a group on its own? Mark Ruskell to move and speak to Amendment 33.
Thank you, Presiding Officer. And if I could declare an interest as an honorary associate member of the British Veterinary Association. Now, it's been 3 years since Parliament partially reintroduced the barbaric tradition of puppy-tail docking that was previously banned under the 2006 Animal Welfare Act. During the last 3 years, there's been no monitoring about how this tradition is being resurrected. In fact, government was explicit after the ban was overturned in Parliament that it would not be monitoring any of the consequences. No figures for the number of puppies that have undergone amputations in Scotland are available. No evidence exists on whether the practice has been restricted to working dogs or has led to many more dogs undergoing a painful procedure purely for cosmetic reasons. There has been no analysis of whether these operations have actually reduced the number of injuries in working dogs, and there has been no guidance given to vets for the certification of puppies destined to become working dogs. I'm also unaware of any further studies, support or guidance available to reduce tail injuries in working dogs, such as tail sheathing or proper kennelling techniques. Tradition, Presiding Officer, is once again trumping evidence in this Parliament. Government is once again simply turning a blind eye to placate a country sports lobby that has the ear of the Cabinet. The lack of evidence is why science-led bodies like the British Veterinary Association, One Kind and Blue Cross continue to oppose the amputation of a healthy dog's tail, and a growing number of veterinary practices are simply refusing to carry out these operations. Because even if we accepted the argument that tail shortening prevents damage in some working dogs, evidence shows that over 300 puppies would have to have their tails docked to prevent the amputation of a single adult dog's tail. Over 300 puppies that may suffer long-term pain, behavioural and communication problems in later life as a result of these operations, simply to avoid one severe tail injury. Now, the animal welfare arguments in favour of the amputation of a healthy puppy dog's tail did not stack up in 2006. They did not stack up in 2017. And there is no evidence to suggest that they do in 2020 either. In fact, there's simply no new evidence at all because nobody is even bothering to look for it anymore. For those reasons, it's time to restore the full ban on tail docking of all dogs, and I move Amendment 33.
Thank you very much, Mr Ruskell. Can I call Gail Ross to be followed by Brian Whittle?
Thank you, Presiding Officer. There is a lot that Mark Ruskell and I agree on, a lot of it in this bill, but I'm afraid this is not one of them. I find the heading of this amendment actually quite offensive because it infers that people who do support the shortening of tails in working dogs are somehow subjecting them to unnecessary suffering. And we have had this debate in 2017 and the Parliament voted on it. Now, I have had representations, and it's not just from the shooting, hunting, land-owning lobby. I've had representations from people that own dogs that are not working dogs that have had injuries to their tails, telling me if my spaniel could hurt its tail wagging it against a door, what on earth is a spaniel doing going into bushes and hurting its tail? We've heard from vets that have had to cut tails off adult dogs and all the suffering that goes along with that. As I said, we had the debate about it, and I do really think that for all the, he talks about evidence gathering, there are a lot of things here today that there are not a lot of evidence gathering on, so that's quite hypocritical as well. I think that it is an animal welfare issue. He's absolutely right, but the animal welfare issue comes when the adult dog has to get its tail taken off, and that is a lot more distressing for the dog than it is when it's done under the... yes, absolutely.
Mark Ruskell.
I absolutely understand the point about distress, but do you think it's 300 times more distressing for an adult dog? Because that's what we're talking about. 300 adult puppies needing to have their tails docked to get the welfare benefit that you're pointing to of one adult dog not having an amputation when it's older.
Gail Ross.
I thank you for that intervention, but I absolutely do not take that just because you have to shorten the tails of 300 puppies, it's 300 times more distressing for an adult. I think that's just a nonsense argument, I'm sorry. So I won't be supporting this. I would urge the Parliament not to support it because, as I said, the animal welfare issue is for the adult dogs and not under the controlled situation where the puppies are having their tails shortened for a very good reason.
Brian Whittle, to be followed by Christine Graham.
Thank you, Presiding Officer. I'm grateful to speak to this amendment. I have to say, as an owner of a working Cocker Spaniel, who I hasten to add is intact with a full tail, even though he wags his tail so much, it bleeds from time to time. And my instinctive position is to rail against any suggestion that a dog such as he should have his tail docked. Indeed, when it came to Parliament in 27, when the current law was implemented, overturning the ban instigated in 2006, it's safe to say I was uncomfortable with supporting any change in the law. I was encouraged to speak to the veterinary community, where I was brought to recognise there are certain rare circumstances where for the welfare of the dog, this procedure should take place. So I did have to ask myself that if a vet had indicated to me that for the welfare and health of my dog he needed his tail docked, would I refuse? Of course, the answer is no. I'm not a vet, and I would always listen to their expert advice, just as I would listen to the advice of any other healthcare professional. I have to conclude that there are exceptional circumstances that may necessitate this procedure, and therefore reverting to an outright ban is the wrong thing to do, and I would ask the Chamber to vote against Mark Ruskell's amendment. Thank you.
Thank you. Christine Graham, to be followed by Claudia Beamish. Christine Graham.
Presiding Officer, I declare an interest as the convener of the cross-party group on animal welfare, and I speak in support of Mark Ruskell's amendment, as I did in an intervention in 2017, and nothing has changed my mind. In fact, it remains even more resolute. I noticed that those arguing against this amendment refer to tail shortening. Why move away from the term docking? It seems to me we're using a euphemism here to conceal something that to me is not necessary for an animal. And if we talk about working dogs, and a working bitch has a litter, she may have 6 or 8 puppies. All of them will have to have their tails docked, but not all of them will become working dogs. For the sake of 1 or 2, the rest go through, even if you believe in that argument. I don't want to spend too long on this because my position is well known. I hope that members will vote with their conscience on this, rather than bother about party whips, which can get in the way sometimes of honesty.
Claudia Beamish, to be followed by Liam MacArthur.
Thank you, Presiding Officer. I wish to speak in support of Mark Ruskell's Amendment 33 in this group. Previously, Scottish Labour has been supportive of a ban on tail docking, and indeed it is. I agree with what is said, that it is to protect dogs from unnecessary suffering. When evidence was taken in the committee in 2017, I was on that committee and was convinced by the arguments then, and they haven't changed now. There were arguments that it was necessary to dock the tails of some working dogs. I wasn't convinced. There's the possibility of a sheath and of bandaging dogs' tails to prevent injuries such as this. And Scottish Labour is supportive of this move to take forward the ban as part of animal welfare. Thank you.
Thank you very much. Liam MacArthur, to be followed by Finlay Carson.
Thanks very much, Presiding Officer. As Gail Ross said, this is the debate that we ran through 3 years ago. Last time, as with this time, it is an issue that provoked a great deal of passionate argument on both sides. As I observed at the time, both sides argued their case weighing up, I think, in the balance, the competing interests in terms of welfare, and the conclusions drawn, I think, were genuinely held. Mark Ruskell mentioned a lack of evidence about the appropriate enforcement of the legislation since 2017, and yet in bringing forward this amendment at stage 3, and therefore no scrutiny prior to that by the committee or this Parliament, nor has he presented any new evidence that it is not being applied appropriately. Those who came to a different conclusion last time, as Christine Graham rightly says, will no doubt feel equally strongly and be equally determined to vote for Mark Ruskell's amendment on this occasion. I understand that. But, on that basis, as in 2017, and like Christine Graham, I think this is an issue where members may well have to vote with their conscience. Applying the party whip may not be appropriate, and my colleagues will vote accordingly as they did in 2017.
Thank you very much. And Finlay Carson to be followed by the Minister.
Thank you, President Officer. As we've heard, the tailed docking was banned in 2007, but to bring it in line with the rest of the UK, the exemptions were put in place for working spaniels, hunt, point and retriever breeds. There is no evidence, either available or presented, that indicates any new welfare concern over this procedure. It's very disappointing that the Greens, as they often do in this place, bring forward amendments which are out with the scope of the bill and don't allow any scrutiny at committee level, and it's some way disrespectful that Mark Ruskell has done this, considering the members of the committee take a very proactive part in looking at legislation we move forward. It will certainly not be agreeing
point of order,
or
sorry,
to this
Mr. Carson,
amendment.
Mr. Carson, sorry, there's a point of order from Mr. Ruskell. Point of order, Mr. Ruskell.
Thank you, Presiding Officer. Can I ask for your guidance about whether this amendment is out of scope in relation to this bill?
It's a good question, Mr. Ruskell, and the answer is no, it is not. It is within the scope of the bill. Mr. Carson.
Presiding Officer, okay, I take on board your ruling. However, it's out with the spirit of this bill. All through this bill process, we have been looking at the sentencing and certainly not bringing forward any new offences.
Thank you very much. Minister Marie Goujon.
Thank you, Presiding Officer. And I think I just have to start by actually refuting some of the claims that were made by Mark Ruskell in his comments there, because they're absolutely outrageous and just completely unfounded. No one has the ear of Cabinet, and we're not trying to revive a barbaric tradition. And this is just the whole purpose of this is just to reignite a debate for the sake of it. Now, I would absolutely agree with the points that have been raised by other members around this chamber, and I think Gail Ross highlighted it and put it very well when she talked about this being done for animal welfare. Now, terms like docking are bandied about to try and again reignite the emotion and reignite the debate. And as Finlay Carson just talked about, it is an offence to dock tails. And Christine Graham's point about there being a differentiation between docking and shortening, well, yes, there is a differentiation between that because they are two completely separate, different things. Now, the provisions in this bill have been carefully developed in close collaboration with the key frontline enforcement agencies to make the most essential improvements they've asked for in animal welfare enforcement. And I am really disappointed that Mark Ruskell has taken the opportunity presented at the last minute of this bill to revive a controversy on a matter that was decided by the Parliament just 3 years ago. And it's made worse by the fact that I've sought at all times to work with others across this chamber to build consensus. I've engaged with Mark Ruskell a number of times at stage 1 and stage 2, and at no point has this issue been raised. And I completely understand the strong feelings and emotive arguments on both sides of the debate of this topic. However, again, they were all fully explored after many years of discussion and debate by detailed scientific analysis and Scottish Government-funded research and a full public consultation. Now, after due procedure and consideration by the relevant committee, the legislation that now allows the tail shortening of specific types of working dogs only to be performed by veterinary surgeons and under very specific conditions was approved by Parliament in 2017. And out with that, tail shortening of dogs is not permitted except for veterinary treatment. Now, there's a fine balance which leaves the decision on whether to carry out tail shortening of working dogs in individual cases to the professional judgment of veterinary surgeons, who are the best people placed to make difficult, balanced decisions about what is in the best long-term interests of individual animals presented to them. And it also means that we actually have significantly tighter legislation on this than other parts of the United Kingdom. Yes.
Mark Ruskell.
Can I thank the Minister for giving way? I think it's welcome that you're listening to veterinary surgeons. Could you also address the concern that veterinary surgeons have that there is no certification of working dogs? There is no template certification that's been produced in Scotland, unlike England and Wales, which gives veterinary surgeons some comfort that they're sticking to the letter of the law. Why hasn't that happened if the government is engaging with the science and engaging with sector bodies?
Minister.
Again, I would say we do have the significantly tighter legislation here, and this is something that is up to the professional judgment of veterinary surgeons. And I think if Mark Ruskell was as concerned about this issue as he claims to be, he would have he has had plenty of opportunity to discuss this with me, but not even during the course of this bill. I'd be happy to discuss that with him at any time prior to that. And at all the time in my role, that issue has not been raised. Now, again, I'm not going to go over and rehash all the arguments for and against the tail shortening of dogs because we've done it. The amendment concerns secondary legislation that doesn't need a bill to amend it, so it doesn't even fit here. And it could be reviewed again in future after proper, detailed consideration of any new evidence if we really think that that is the best use of our time. However, the place to consider this subject in any more detail should not be here today, so I oppose the amendment and would ask Mark Ruskell to withdraw it.
Mark Ruskell to conclude in this section and to press or withdraw his amendment.
Thank you, Presiding Officer. I will be pressing this amendment. And I think what we've seen over the last 3 years is the Scottish Government refusing to monitor and review its own legislation. This was put in place against the wishes of bodies that represent the veterinary sector in Scotland. They have raised concerns about this. There was no monitoring of the rollout. The Minister cannot tell me today how many puppy dogs' tails have been docked in the last 3 years. She cannot tell me what the welfare benefits are. All we hear is anecdotal responses from inboxes from Gail Ross and others about how they feel that there is a net animal welfare benefit to this tail docking, partial lifting of the tail docking restriction. What I want to see is evidence. I've asked for evidence in written questions over the last 3 years, and I've had a plain response from the Scottish Government that they are simply not looking at the evidence, they're not monitoring. So I would simply ask the Scottish Government to make a commitment here today, going forward, to actually review and monitor your own policy on this. If you think that there is a net welfare benefit to this measure, then prove it, monitor it, check that it's actually working, check that it's doing what the government said it was going to do 3 years ago. We don't have that evidence, and as a result, I think we should be restoring the full ban again.
Thank you very much. So the question is that Amendment 33 be agreed to. Are we all agreed? No. We're not agreed. I'm afraid this is the first division of the afternoon, so we're going to suspend for 5 minutes while I call members to the chamber. Parliament suspended for 5 minutes. Thank you, colleagues. I think we can resume. So the question is that Amendment 33 be agreed to, and members may press their voting buttons now on Amendment 33. This is a 30-second division. The result of the vote on amendment number 33 in the name of Mark Ruskell is yes 22, no 56. There was one abstention. The amendment is therefore not agreed. We're going to move on now to Group 3, disqualification order. Can I call amendment 34 in the name of Maurice Golden? This is grouped with amendments 35 and 63. Maurice Golden to move amendment 34 and speak to all the amendments in this group.
Thank you, Presiding Officer. I am pleased to propose this amendment, having raised the issue of disqualification orders during the passage of the bill, as is the appropriate, fair and balanced way in which to bring amendments that are acceptable to this chamber. A theme of discussions during the passage of this important bill has been consistency of sentencing, including the use of disqualification orders. My Amendment 34 seeks to address this by making it a requirement for courts to consider the use of disqualification orders in the way they were always intended to be used. That is, an animal protection measure rather than a form of punishment. This requirement will apply to all relevant animal welfare cases and require courts to explain their reasons for imposing disqualification orders of this type specified, or not imposing a disqualification order, and require a record to be kept for their reasons. I hope this will improve the consistency and transparency of these court judgments and provide us all with a better sense of how courts are using all the tools available to them to protect animals and to address the worst harms and offences. Presiding Officer, Amendment 63 is a technical amendment. It will modify the long title of this bill to include a reference to the proposed requirement on courts to consider making disqualification orders following convictions for animal welfare offences. I hope members will support both amendments, and I move Amendment 34 in my name, and I look forward to hearing further information from Colin Smith on Amendment 35 within this group.
Thank you very much, Mr Golden. I call Colin Smith to speak to Amendment 35 and the other amendments in the group.
Thank you, Presiding Officer. First of all, I welcome Amendment 34 from Maurice Golden, which looks to improve the use of disqualification orders. During stage 1, a number of stakeholders highlighted the inconsistent use of disqualification orders, and this is an issue both Maurice Golden and I brought forward in amendments at stage 2. When considering what changes were needed at stage 3, there were 4 key issues that were highlighted to me by a number of organisations such as One Kind. Firstly, the need to clarify that the default position in all cases should be for the court to consider a disqualification order. Secondly, the need for a clear requirement for the court to state the reasons for its decision, whether they decide to issue an order or not. Thirdly, the lack of records on the use of disqualification orders, which could be addressed through a new requirement for the Crown Office to keep a record of all disqualification orders and applications to vary or delete them. And fourthly, the need for clarification that a disqualification order, while part of the sentence imposed by the court, is not a penalty in itself. Combined, these 4 changes would clarify the purpose of disqualification orders, encourage their proper use and help us gain a better understanding of how and when they are used and identify any existing issues with their use. I believe Maurice Golden's amendment successfully tackles the first 3 issues well. If there's a gap in it, it's addressing the 4th point, so that is the aim of my Amendment 35, which is designed to be a helpful addition to Maurice Golden's amendment. This amendment in my name looks to clarify in law that disqualification orders are a means of protecting animal welfare. They are issued to prevent those convicted of animal welfare offences from owning or working with animals. That is not a punitive measure, but an animal welfare measure. The law as it stands suggests that such orders can be used instead of any other penalties. Amendment 35 in my name would remove this and make clear that they should be issued as needed for the future protection of animals, not as an alternative to a penalty. The line in the legislation, if amended, would read, "A disqualification order may be made in addition to any other penalty or order which may be imposed in relation to a relevant offence." It does not say they can only be issued alongside a penalty, even although I cannot think of a scenario whereby a disqualification order would ever be deemed appropriate on its own without a penalty such as a fine. What my amendment simply states is that a disqualification order should not be issued as an alternative to a penalty, and I'm sure that will be made very clear in any guidance on this legislation. So, Presiding Officer, I would therefore urge members to support both amendments 34 and 63 in Maurice Golden's name, and also my amendment 35.
Thank you very much, Mr Smith, and I call the Minister, Mary Gouchon.
I fully support Maurice Golden's amendment and the rationale for it. And regarding Colin Smith's amendment 35, I absolutely support the intention behind the first part of the amendment, and it is similar to Maurice Golden's amendment on this subject. But while the second part of the amendment is also equally well-intentioned, I'm concerned that it does stray too far into the territory of limiting the discretion of the courts in terms of how they use the penalties and powers that are available to them after conviction for a relevant welfare offence, because that isn't something that government or indeed Parliament should be doing. Now, Amendment 35 seems to be intended to prevent disqualification orders being issued on their own, and while that might not be a common scenario, in some circumstances, this might actually be appropriate depending on the individual facts and circumstances of a particular case, bearing in mind that there are widely varying circumstances in which relevant animal welfare offences of different types might be committed. And I think what's important is that we don't inappropriately fetter the ability of courts to make that decision. So for that reason, I cannot support this amendment, and I hope that Colin Smith might consider not pressing it, but if he does, I would urge members not to support it.
Thank you very much. And I'm calling Maurice Golden to wind up on this group and to either press or withdraw Amendment 34 in his name.
I'd like to press.
Thank you very much, Mr Golden. So the question is that Amendment 34 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 35, Colin Smith, to move or not move?
To move, Presiding Officer.
That is moved. So the question is that Amendment 35 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division on Amendment 35. Members may vote now. This will be a 1-minute division. The result of the vote on amendment number 35 in the name of Colin Smith is yes 42, no 38. There were no abstentions. The amendment is therefore agreed. We're going to turn now to Group 4 on vicarious liability. Can I call Amendment 36 in the name of Claudia Beamish? And this is grouped with the amendments as shown in the groupings. Claudia Beamish to move Amendment 36 and to speak to all the amendments in this group.
Thank you, Presiding Officer, and I move Amendment 36 in my name. Presiding Officer, these amendments seek to extend vicarious liability provisions to certain offences in the Wildlife and Countryside Act 1981 and the Wild Mammals Protection Act 1996. The offences referred to are, on the whole, not only heinous crimes of cruelty to wildlife, but also significant in the midst of an environmental emergency. I welcome that the Minister has sought to work with me on Amendment 39. This seeks, for clarity, to allow for the option of extending the established vicarious liability provisions in the Wildlife and Countryside Act 1981 to offences involving the illegal setting of traps and snares. We know that birds of prey are still being harmed, sometimes fatally, by pole traps and uncovered spring traps. In the last year, Police Scotland has investigated incidents involving spring traps next to a hen harrier nest, and we have seen all the images of a golden eagle in flight with what appears to be a spring trap on its leg. I hope that by introducing vicarious liability to these offences, it should act as a deterrent and a wake-up call to those very few individuals who still will not respect the law, including some landowners or land managers of land on which offences are committed, as well as individuals who commit these offences. I still consider the amendments extending vicarious liability to the other offences that I have listed to be necessary. I've listened to the Minister's concerns with the legal drafting, and I addressed them after stage 2. And these are, in brief, 36, which I've already moved, the sale and care of possession or transport of protected wild birds and their eggs; 37, the failure to meet legal registration requirements for captive birds and their eggs, or keeping them illegally due to a past conviction for their ill treatment; 38, the illegal confinement of protected birds; and 40, the taking of wild hares in the closed season, the intentional destruction of wild plants which are protected, including their sale, and the possession and sale of invasive animals or species of plants. 53 highlights the grievous offences found in Section 1 of the Wild Mammals Act 1996, mutilation, beating, stabbings, etc., of any wild animal with intent to inflict unnecessary suffering. And 54 is consequential to 53. From our discussions, I'm aware the Minister has reservations about the justification of these offences having vicarious liability applied to them. But I argue that this is a strong message of deterrence that must be focused on. We're talking about very few, but there are bad landowners and land managers aware of or permitting these crimes, and they should shoulder the penalties. These are illegal acts that can easily go unreported, but they can also be reported, and they can be very cruel and cause environmental loss as well, and should be taken very seriously. And with the introduction of vicarious liability, the onus is on the landowner or employer to properly train their staff to ensure that they know the law and with regard to wildlife, as much as they would be responsible for health and safety or other issues on any estate or any land. You could say that vicarious liability introduction in these areas is an important improvement of the working conditions of gamekeepers. Furthermore, vicarious liability has been shown to be a beneficial addition when used alongside other measures. In the past, it was introduced along satellite tagging of birds. Alongside that, these two measures in tandem serve to reduce the incidences of raptor poisonings in Scotland. In terms of other measures, it would perhaps be worthwhile stressing that the penalties which are proposed in other amendments serve as a complementary set of proposals that would work alongside this expansion of vicarious liability. I also wish to speak in support of Mark Ruskell's Amendment 1, which relates to badger setts. I'm quite clear that the destruction of such setts is as serious as the killing or injuring of a badger itself in terms of the damage caused. In the case of a badger set, it would be difficult for those in charge on the land not to know of such a thing that was happening. And it would surely take quite an amount of person power to destroy a set. Thus, a vicarious liability clause is vital in the protection of this species to send a clear message to that minority of landowners and agents and employees who risk flouting the law with this serious crime. There is a limited basis for vicarious liability, as is found in the 2011 Act. And the owner or manager of the land has very limited liability and also has a clear defence at their disposal. So I ask members across this chamber to support all of the vicarious liability amendments in this group, including Mark's as well. And I very much hope you will, because this will really add to protection for wildlife and our environment across Scotland. Thank you.
Thank you very much. I call Mark Ruskell to speak to Amendment 1 and the other amendments in the group.
Thanks, Presiding Officer. I support all amendments in this group and very much welcome the work of Claudia Beamish in leading the arguments, I think, in committee around extension of vicarious liability. My Amendment 1 extends the provision vicarious liability in offences relating to badges. However, it also protects landowners and managers from liability if the employee or agent commits the offence out with their employment or land. Now, this is a tighter amendment than the one I lodged at stage 2. It narrows that liability down. It mirrors the existing provision and definitions in relation to birds. And I have attempted to work with the government on this, but there seems to be a more underlying concern about vicarious liability from the government, and I'm still trying to pin down the reasons for that, because vicarious liability seems to be working. It does seem to be driving action by landowners to avoid committing offences in relation to birds and pesticides, and of course it remains a very high bar for prosecution. Yes, I'll give way to Mr. Mountain.
Edward Mountain.
I thank the member for giving way, and I support the member's intention to stop the damaging of badger sets. It's not something that we should condone. I am a farmer, and it's in my register of interest, and occasionally badgers do wander and form temporary sets in fields which may be ready for harvest. It could be an accidental action to drive over the badger set, which you don't know exists, and that is perfectly possible with a combine, unless you walk every inch of the field before you go there. It would not be your intention, would it, Mr. Ruskell, to punish somebody who did it accidentally without knowing that the badger set would be there?
Mark Ruskell.
Well, these are not birds of prey. These are not ephemeral species that are flying around Scotland. Their territories, their habitats are well known. And if there's an existing woodland where there's an existing badger set and badgers move from that area into your field, Mr. Mountain, I would expect you to take due care and to ensure that that badger set is not destroyed. And I think landowners will recognise that. A vast majority of landowners in Scotland will be very, very well aware whether they have badgers on their land or not. I'm surprised if you don't. I need to make some progress, Presiding Officer, on this. Badgers are, of course, territorial animals living in really big, identifiable sets. And in the majority of these cases, they have existed for decades. It is virtually impossible for a landowner or manager to not know that badgers exist on that land. Now, the briefing from Scottish Land and Estates tells us that badgers are widespread, and therefore everything's okay, and none of the legal protections need to change. But I have pictures, and I'm sure members have been sent this as well, from Scottish badgers, of so many horrific cases of set destruction and the death of whole families, maimed, crushed, and asphyxiated, incidents where it's been impossible to pin down liability when there are contractors, subcontractors, agents and landowners all passing the buck. So I don't think everything is okay on this. I think we need to be tightening the protection of badgers, tightening up the penalties, extending the penalties, but also introducing vicarious liability. And I would say that, law-abiding landowners and managers have nothing to fear from vicarious liability being applied to badger offences. But those who willfully allow set destruction and persecution to take place need to be brought to justice. Without vicarious liability, this kind of reckless destruction will continue to be met by a wisne-me attitude, and one of our most iconic species of wildlife will continue to suffer a very heavy price.
Thank you, Mr. Ruskell. And the call, Finlay Carson, to be followed by Lee MacArthur.
Thank you, Presiding Officer. I'll address the amendment number 1 by Mark Ruskell. Now, we oppose the amendment because there's already offences in existence which, if you knowingly cause or permit damage to a badger set. We recognise that badgers are protected, but they're widespread and they're not considered a species of concern with SNH. They've got a healthy population spread and distribution across Scotland. So we don't see that this amendment serves any useful purpose because it's targeted at an area of law which we believe is working well. My intervention was to ask the member, and maybe want to intervene, is whether he understands that persecution is normally limited to poachers or badger baiters with dogs rather than landowners, the type that this vicarious liability amendment would change.
Mark Ruskell.
Thank the member for giving way, and apologies I didn't let him in earlier on. I think that is the case, but I think Mr. Carson also needs to recognise that there are cases where housing developers, forestry operators have destroyed sets, and it's been almost impossible to bring those agencies to justice through the criminal prosecution system. This is why vicarious liability is important. It's important to pin down that liability because the buck keeps getting passed from one contractor to a subcontractor back to the landowner again, and these cases are not being brought forward. They're not being brought forward successfully.
Finlay Carson.
Thank you, Presiding Officer. Your intervention allows me to raise the issue which the Law Society has brought up, and suggesting that, you know, that if there are examples of circumstances and cases where the Crown Office Procurator of Fiscal Services are unable to prosecute, well, that would be useful to know about, and those gaps could be filled where the law requires to be extended. And the suggestion that to criminalise vicarious responsibility would effectively extend the law, which this bill was understood not to do. The Law Society also states that the vicarious liability tends not to form part of the criminal law, as a person is normally only liable for their actions and not the actions of others. So if we were to apply it here, where an employee commits an offence in the course of their employment, the employer could be held criminally liable for the actions of the employer unless due diligence defence applies. So it would be a new offence if this was to be brought in. I firmly believe that the extension of vicarious liability in this case, but also in Claudia Beamish's amendments, requires far more consultation and to receive proper scrutiny rather than be brought in this fashion. I'd like to address Claudia Beamish's amendments. As I've already said, the vicarious liability does tend to be a blunt tool and effectively reverses the burden of proof that a landowner or manager can be found guilty unless they are able to prove that they've briefed and trained and instructed employees. Now, when it comes to snares, we know that the Snare Training Scotland order introduces the requirement for all snare operators to be trained, for all snares to be identified through a tag or which is registered through Police Scotland. And additionally, SNH has also made it a requirement of the General Licence 2020 for individual trap operators to also attach personal identification to each predator trap. Now, we're not aware of any concerns that have been raised by SNH, and as far as we understand, the number of offences regarding illegally set snares have been minimal. Pest control is absolutely integral to the land management in Scotland, and this amendment is likely to have unintended consequences on the conservation of some of our most vulnerable species, and that includes ground nesting birds. So we can't support this without the evidence or data to show need, and I don't believe we've given it due consideration at this stage to actually make a decision on it. So we'll be voting against all the amendments in this group relating to vicarious liability.
Thank you very much. And I call Liam MacArthur to be followed by Edward Mountain. Mr MacArthur.
Thank you, President Officer. At stage one, I expressed the view that there was a case for looking at how vicarious liability first introduced in relation to wildlife crime through the 2011 Wildlife and Natural Environment Bill might usefully and sensibly be extended. I was interested by Mark Russell's comments about its effectiveness. Having been involved in the committee that scrutinised the Wayne Bill, I was under the impression that there was a general acceptance about the limitations of vicarious liability, either as a deterrent or as a means of punishing those at whom it was targeted. I think Mark Ruskell is absolutely right in commending Claudia Beamish, however, in her efforts in leading the exploration of options for such an expansion, though I think a number ultimately seem problematic in the way that it would work in practice. That said, unlike Finlay Carson, Scottish Liberal Democrats strongly support the extension of vicarious liability in relation to the use of snares, etc., and will therefore be happy to support Claudia Beamish's Amendment 39. Thanks very much.
Thank you. And I call Edward Mountain to be followed by the Minister.
Thank you, Presiding Officer. I rise just to correct a point of fact that Mr Ruskell made. Mr Ruskell says that badgers are territorial and they live in sets. Indeed, he is right. But when those sets become full, the animals move out and set up new colonies and new sets across the countryside. And Mr Ruskell cannot be blind to the movement that is happening at the moment, which happens at this time of year when badgers are moving out because cubs are being born and the mothers are protecting the cubs within their set and forcing non-mature or mature adults who are not part of the social clan to move out. which then established temporary holding areas across the land. And I have seen, Mr Ruskell, young badgers moving into areas. I can give you an example of one actually going down a crack caused by dry weather and holing up in there because it had been forced out and there was nowhere for establishing its set. And that is the kind of thing that worries me, that we are going to accidentally catch up people who have no intention of damaging the badger or the badger's set, but genuinely don't know that they are there. And I'm sorry, Mr Ruskell, I offered the First Minister to come for a walk with me in the countryside to see what it's like. She refused me. I'll offer you a walk to come into the countryside to have a look at badger sets, and I can show you plenty, and I can demonstrate my example. Take me up if you want to, Mr Ruskell.
Can I call the Minister, Marie Goujon?
Thank you, Presiding Officer. During stage 2, in response to the arguments that had been advanced by Claudia Beamish and Mark Ruskell, I said that I didn't believe it was necessary, practical or proportionate to seek to apply a change of vicarious liability to the numerous offences that they sought. However, I did agree that I would go and look again at what had been proposed. And after giving it very careful thought and consideration, I think it wouldn't be unreasonable for the charge of vicarious liability to be applied to certain trapping and snaring offences. I believe that Claudia Beamish's amendment is a narrow and proportionate amendment which importantly applies the same criteria as the existing offences within the Wildlife and Countryside Act with regards to who can be held vicariously liable. So the Government is therefore supportive of Amendment 39. And turning now to the other amendments that have been brought forward by Claudia Beamish. Amendments 36, 37 and 38 would apply the charge of vicarious liability to a number of offences under the Wildlife and Countryside Act, including offences related to the protection of wild plants or the keeping or sale of invasive animals. However, just as I said at stage 2, I haven't heard any compelling reasons to demonstrate that vicarious liability is appropriate for those offences. We just don't have the evidence to show that landowners and managers have been complicit in crimes of that type. And with regards to Mark Ruskell's amendments, these would apply vicarious liability to Section 1 of the Protection of Badgers Act, and that's offences involved in the taking, injuring or killing of badgers, and Section 1(3), possession of a dead badger or a part thereof. Now, I absolutely appreciate the efforts made by the member in working on this amendment and the engagement that took place before bringing it forward to stage 3. But these amendments have significant drafting deficiencies in that it isn't at all clear who they're aimed at and who they would apply to. Now, we've discussed already today the importance of specificity when it comes to matters of criminal law. And, for example, Amendment 1 extends the application of vicarious liability to any owner or manager of land where badgers are found. This is extremely wide-ranging and a non-exhaustive definition, and so it opens up the possibility of a vicarious liability prosecution to be taken against a whole host of individuals, but it doesn't clearly define who those individuals are. And I'd also like to draw members' attention to the fact that 12B of the Protection of Badgers Act states that if a director knows anything about an offence made by their corporate body or has demonstrated neglect resulting in an offence, they too can be prosecuted. It's also important to remember that there is already an existing offence for someone to knowingly cause or permit to be done some of the offences covered by Amendments 36, 37, 39, 40 and 1. So that means that should an employer or land manager instruct an employee to commit one of those offences, they will be liable for that offence. So, in summary, I've looked at this situation very carefully and Amendment 39 has been brought forward to extend the existing vicarious liability provisions under the Wildlife and Countryside Act 1981 to certain offences involving traps and snares. However, I do have serious concerns about the remaining amendments in this group, and that's why I won't be supporting them.
Thank you very much. And I call on Claudia Beamish to wind up in this section and to press or withdraw Amendment 36.
Thank you, Presiding Officer. I will be pressing Amendment 36. I'm very pleased that after discussion with the Minister, having worked with others, including Mark Ruskell as well, on vicarious liability, that Amendment 39 will be accepted by the Scottish Government, because illegal traps and snares are something that is completely unacceptable, and it's very unlikely that these will be used, but it is an absolute deterrent to preventing them. And I don't actually agree with Finlay Carson that because there's training in place for the setting of legal snares, that this has any impact on if somebody's going to be ruthless and callous enough to use one of the illegal ones. So I'm very pleased that that has been moved forward as vicarious liability by the Scottish Government, and I hope other parties will support that. I think it is very important that we do have robust vicarious liability arrangements on a wider range of offences, and that those become serious offences. I believe they are proportionate amendments, and there is a clear defence for land managers and owners at their disposal. Just to refer to Edward Mountain's comments, that I'm absolutely clear that if somebody genuinely doesn't know that they're doing something, then there is a defence, and that would relate to badgers extending their colonies in spring and things that he's highlighted of that kind. So it is a limited liability, and I think it's important that we're able to take these forward, and I ask for the support across the Chamber today to make these serious offences for those few who may commit them. Thank you.
Thank you very much, Mr. Commissioner. The question is that Amendment 36 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote. This will be a 1-minute division. Amendment 36. The result of the vote on amendment number 36 in the name of Claudia Beamish is yes 21, no 59. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 37, Claudia Beamish, to move or not move?
Move, Presiding Officer.
That is moved. The question is that amendment 37 be agreed to. Are we agreed? No. We're not agreed. We'll move to a vote. Members may cast their votes now on amendment 37. The result of the vote on amendment number 37 in the name of Claudia Beamish is yes 21, no 59. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 38, Claudia Beamish, to move or not move?
Move, Presiding Officer.
That is moved. The question is that amendment 38 be agreed to. Are we agreed? No. We're not agreed. We'll move to a vote on amendment 38. Members may vote now. The result of the vote on amendment number 38 in the name of Claudia Beamish is yes 21, no 59. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 40 in the name of Claudia... Sorry, amendment 39, beg pardon. Amendment 39 in the name of Claudia Beamish. Claudia Beamish to move or not move?
I move, Presiding Officer.
Thank you very much. The question is that Amendment 39 be agreed to. Are we agreed?
Yes.
We're not agreed. We'll move to a vote on Amendment 39. Members may vote now. The result of the vote on amendment number 39 in the name of Claudia Beamish is yes 61, no 19. There were no abstentions. The amendment is therefore agreed. Can I call amendment 40, Claudia Beamish, to move?
Yes, move, Presiding Officer.
Moved. The question is that amendment 40 be agreed to. Are we agreed? No. Or not agreed? Move to a vote on amendment 40. Members may vote now. The result of the vote on Amendment 40 in the name of Claudia Beamish is yes 21, no 59. There were no abstentions. The amendment is therefore not agreed. We're going to turn now to Group 5. This is on Penalties for Offences, Wildlife and Countryside Act 1981. Can I call Amendment 41 in the name of Angus MacDonald, grouped with the amendments as shown, and Angus MacDonald to move Amendment 41 and speak to all the amendments?
Thank you, Presiding Officer. As we all know, egg collecting continues to pose a very real threat to our rare Scottish bird species. However, it's fair to say that there has been progress on stamping out this inexcusable damaging practice in recent years through targeted policing campaigns such as Operation Easter, but I'm aware there have been significant cases involving wild birds' eggs both in Scotland and elsewhere in the UK. Clutches of eggs laid by the rarer birds are the main target of egg thieves, who are known to travel the length and breadth of the country to steal eggs for their collection. These people think nothing of robbing birds such as the golden eagle, the black-throated diver and the dotterel of their eggs. This is done in the full knowledge that their actions invariably eliminate any breeding opportunity for the birds for that year. Many bird species are becoming less common for a number of ecological and environmental reasons, so they can well do without the added pressure of egg thieves. Allowing the offence of possession, sale and transport of wild birds' eggs to be triable either way, and therefore warrant a maximum penalty of 5 years and/or an unlimited fine on conviction on indictment, has the potential to help address such offending by strengthening the sanction for the worst crimes. It also provides consistency in the approach to the treatment of offences involving birds' eggs throughout the Act, and importantly demonstrates how seriously the Scottish Government considers the matter, or these matters. So in short, we need a stronger deterrent. So, Presiding Officer, I urge members to support the amendments in this group, and I move Amendment 41. Thank you.
Thank you, Mr MacDonald. Can I call Claudia Beamish to speak to Amendment 42 and the other amendments in the group?
Thank you, Presiding Officer. My amendments in this group seek to increase the penalties for wildlife crimes done to nesting, resting and lecking places of protected wild birds and animals. I found out that lecking places is where they do their lovely mating dances, so there we go. The existing proposals do not sufficiently reflect their seriousness, and nor do they deter criminal activity. As mentioned before, these offences also affect our very precious biodiversity, the loss of which makes Scotland all the poorer. I want to thank RSPB, SWT and evidence from Environment Link and the Bat Conservation Trust on these amendments. I've raised these concerns at all stages of the bill, from the Stage 1 report on the, with other committee members to the testing of amendments at Stage 2, and I believe these amendments are now refined to address any concerns from the government, and I appreciate having been able to work with the Minister on these. Damage or destruction to resting places and breeding sites can have an equivalent outcome of direct harm to an animal, thus intentionally or recklessly damaging or destroying should carry the equivalent penalty. The unlimited fine is particularly vital as there are cases where offenders can benefit very well financially from not following the law when the development of land, etc., to provide alternative roosting places can have a greater cost than the existing fine. We will also be supporting Angus MacDonald's amendments 42 and 44, and I appreciate him having let us know a bit more detail about these before today. Egg collecting, while more rare than it used to be, and certainly not at all socially acceptable, it continues to pose a very real threat to our rare bird species in Scotland. And these amendments would allow the offence of possession, sale and transport of wild bird eggs to be triable either way, depending on the seriousness of the crime. And an unlimited fine or conviction for 5 years on indictment would certainly be a deterrent. Has the potential to address such offending by strengthening the sanctions for the worst crimes, and also allows consistency in approach of treatment to offence involving bird eggs throughout the Act. I'll end my remarks with a quote from the Priority Review. We consider that it is appropriate to match the maximum penalties available in other areas of environmental law, as certain wildlife crimes are as significant in conservation and animal welfare terms as the environmental impact of a water, air or waste pollution offence. Thank you, Presiding Officer.
Thank you, Ms Beamish. And I call the Minister to speak to Amendment 14 and the other amendments in this group.
Thank you, Presiding Officer. It's customary for the Scottish Government to consider the effect on the drafting of amendments accepted at Stage 2 of a bill process, and not least to check if any housekeeping is required. And that's really the purpose of my amendments 14 and 27. They seek to correct Section 21 of the Wildlife and Countryside Act 1981, which provides the penalties for the offences within that Act to remove duplication of references to offences. Amendment 14 repeals subsection 4ZZA of Section 21 of the 1981 Act, as the penalties for the offences listed in that subsection are already provided for in Section 21, subsection 4C. And Amendment 27 simply removes the specific reference to Section 15A2A from Section 21 of the 1981 Act, as that Section 21 already provides penalties for the whole of Section 15A. And so the specific reference to Section 15A2A is unnecessary. I would hope that these technical amendments prove uncontroversial and that members would support them. On Angus MacDonald's amendments, I want to thank him for laying these. As he stated, there are still individuals who believe that the collection and trade of rare bird eggs is an acceptable activity, and I'm absolutely clear that it is not. These offences, while thankfully perhaps less common than they once were, nevertheless still pose a serious threat to endangered bird species, and so I'm happy to support these amendments. Presiding Officer, when Claudia Beamish brought forward her amendments at Stage 2, I said that I would like some time to consider their consequences further, and I appreciate that Claudia Beamish provided that time. And having considered all the evidence heard throughout the bill process, and importantly taken soundings from government officials in justice, as well as animal welfare, and importantly from the Cabinet Secretary for Justice, I am happy to support these amendments. The destruction of nests and habitats can have a serious impact on the welfare and conservation status of wild birds, and the penalties now proposed will provide the Crown Office and Procurator Fiscal Service and the courts with the necessary flexibility to deal appropriately with these crimes. I will support all the amendments in this group and hope members will too.
Thank you very much. And I call Liam MacArthur to be followed by Finlay Carson.
Thank you, President Officer. I simply want to add my thanks, not just to Angus MacDonald, but particularly to Claudia Beamish for her amendments. As I said previously, at the heart of this bill is a need to toughen up penalties for wildlife crime and animal cruelty by increasing the maximum penalties for offences related to disturbing, destroying or damaging birds and animal nests and shelters. Claudia Beamish is helping to ensure that happens. And therefore, Scottish Liberal Democrats will be happy to support all of the amendments in this group.
Thank you very much. Finlay Carson.
Thank you, President Officer. Given that all the amendments in this group are related to the main principle of the bill, and that's to increase the penalties associated with animal welfare offences, we'll be supporting all the amendments.
Thank you. And to be really brief, can I call on Angus MacDonald to wind up if he wishes to make any concluding comments, and to press or withdraw Amendment 41?
Nothing to add, President Officer. Happy to move Amendments 43 and 46.
Thank you very much. It's Amendment 41 first, but we'll move straight to the question. The question is that Amendment 41 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 42, Claudia Beamish, to move?
Yes, move, Presiding Officer.
That is moved. The question is that Amendment 42 be agreed to. Are we agreed? Yes. Thank you. Amendment 43, just to confirm, Angus MacDonald is moving.
Moved.
Thank you. The question is that Amendment 43 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 44, Claudia Beamish, to move?
Move, Presiding Officer.
That is moved. The question is that Amendment 44 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 14, the Minister, to move formally?
Moved.
Thank you very much. The question is that Amendment 14 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 45, Claudia Beamish, to move or not move?
Yep, move, Presiding Officer.
Thank you. That is moved. The question is that Amendment 45 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 46, Angus MacDonald, to move?
Moved.
Thank you. Confirmed. The question is that Amendment 46 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 47, Claudia Beamish, to move?
Move, Presiding Officer.
Thank you. The question is that Amendment 47 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 48, Claudia Beamish, to move?
Move, Presiding Officer.
That is moved. The question is that Amendment 48 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 27, the Minister, to move?
Moved.
Thank you very much. The question is that Amendment 27 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. We're going to turn now to Group 6. This is on Food and Environment Protection Act 1985, penalties for offences. Can I call Amendment 28 in the name of Claudia Beamish in a group on its own? Claudia Beamish to speak and move Amendment 28.
Thank you, Presiding Officer. This amendment is about increasing the penalties of offences, this time for illegal pesticides. Members may recall at stage 2 I received cross-party support to increase penalties for possession of these pesticides and the causing of possession of illegal pesticides. This amendment seeks to extend this to include the sale of the said illegal pesticides. These illegal pesticides can be untested and potentially very dangerous to human health and to the environment. And I hope that people across the chamber will agree that this legislation must do all it can to resolutely deter illegal pesticide use, so it may never be a problem in Scotland again. Thank you.
And can I confirm the member is moving the amendment? Thank you.
Presiding Officer, while I understand the motivation behind Claudia Beamish's amendment, I can't support it for a number of reasons. First of all, this amendment has a number of technical issues, and I'm concerned that as drafted, this amendment is fundamentally flawed. The intention behind it appears to be to increase the penalties for offences relating to prohibitions on the importation, sale and supply of pesticides. However, the amendment fails to properly identify the power in Section 16 of the Food and Environment Protection Act 1985, under which such prohibitions are made, or, for that matter, under which the offences arise. So, due to the way in which the amendment has been drafted, it's doubtful that the increased penalties which it mentions will apply to any offences under the 1985 Act. And secondly, the provisions that this amendment seeks to change have largely been overtaken by EU legislation, which provides for rigorous and effective pesticide regimes in Scotland. And finally, this is an animal and wildlife bill, and the purpose of which is to enhance the protection afforded to domestic, wild and farmed animals. However, this amendment is taking the bill into areas that are far wider than just animal welfare considerations, and it's my view that this bill just isn't the appropriate place to make changes that relate to more general pesticides regulation offences. And given all of that, I would ask Claudia Beamish to withdraw her amendment.
Thank you. Colin Finlay Carson.
Thank you, Presiding Officer. We were minded on first reading this amendment to agree with it because we certainly don't condone the ownership of pesticides where there's no legitimate reason to have them, and anybody in possession of those should face the full brunt of the law. And we would have supported the increased penalties for those offences. However, given the comment to the Minister and the technical issues that might arise for this amendment, we'll not be supporting it.
Thank you very much. Claudia Beamish to wind up in this group and to press her withdraw her amendment.
Thank you, Presiding Officer. It's at a late stage, but I am going to withdraw the amendment. However, I do want to have on the record in this chamber that the sale of illegal pesticides is something that across the EU has become a very serious issue, and their importation as well. And I hope that this will be addressed in other ways. I appreciate what the Minister is saying about it being too wide, and perhaps I could have had further discussion with her in the interim, but it was building on the previous amendment which was agreed cross-party, and I think that I would just highlight that there are actually criminal gangs who import illegal pesticides and sell them on the black market across Europe, and this is a very serious issue that we need to address together. Thank you.
Thank you very much. Ms Beamish is going to withdraw Amendment 28. Does any member object? No. Moving on to Amendment 1. I'm going to call Amendment 1. This was debated earlier in the name of Mark Ruskell. Mark Ruskell, to move or not move?
Move.
That is moved. So the question is that Amendment 1 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote on Amendment 1. And members may cast their votes now. This follows a new grouping, so we'll have a 1-minute division on this vote. Call Amendment 1. Vote on Amendment 1. And I would remind members who are not in the chamber, they've got a minute to get back in. The result of the vote on Amendment number 1 in the name of Mark Ruskell is yes 20, no 57. There were no abstentions. The amendment is therefore not agreed. We're going to turn now to Group 7. This is on the Protection for Badgers Act 1992, penalties for offences, etc. Can I call Amendment 49 in the name of Colin Smith, grouped with Amendments 50, 51 and 52. Colin Smith to move Amendment 49 and to speak to all the amendments in this group.
Thank you, Presiding Officer. Amendments 49, 50 and 51 in my name look to increase the maximum penalties for interfering with or damaging a badger set to bring them into line with the proposed new penalties for harming a badger directly. Destroying a badger set can cause at least as much damage as killing a badger directly and can often cause more harm by causing elongated suffering, more drawn-out and painful deaths, or by harming entire groups of badgers and risking local extinction. While the bill as drafted rightly increases the maximum penalties for offences against badgers, it does not do the same for crimes involving sets. This creates a loophole allowing people to kill an entire group of badgers in a cruel and inhumane way by damaging their sets with less severe consequences than killing an individual badger. There's no reason for damaging a badger set other than to harm the animals, and that needs to be reflected in the penalties. Having raised this issue previously, I welcome that the Minister acknowledged my concerns and the merit of my intended amendments at Stage 2, and I want to thank her for agreeing to work with me to bring these amendments back at Stage 3. Amendment 49 gives effect to the intended purpose by repealing the circumstances in the current legislative provisions contained which allow for lower penalties to be applied. Amendment 50 then repeals those penalties, and Amendment 51 then applies the higher penalties to all of the now amended Section 12 of the Protection of Badgers Act. Increasing the maximum penalties for such crimes and bringing them into line with the penalties for offences against the animal will send a clear message that disrupting a badger set is a serious wildlife offence. I hope members will therefore agree and support my amendment, and I formally move Amendment 49. Amendment 52 in my name raises a separate issue and therefore is set out in a different standalone amendment. It is, however, a related matter, specifically the definition of a badger set. It is important that penalties for disrupting a badger set are set correctly, but equally for this to matter, the laws must be effective. One potential limitation of the legislation that has been raised with me by Scottish badgers is the definition of a badger set. As it stands, badger sets are defined as any structure or place which displays signs indicating current use by a badger. However, there is a case to be made that the requirement for a set to be in current use may be too narrow. As badger sets are typically used on a rotational basis, it is possible to do harm to the welfare and health of badgers by damaging a set that is not currently in use. However, I'm mindful that changing a legal definition is a significant step and not to be taken lightly or without proper thought and consultation. I did have an amendment drafted that would have set a new definition, and I raised this issue directly with the Minister. However, in light of the Minister's comments and request to be able to consider this matter in more detail, I haven't tabled that amendment, and I've sought to change and not to change this definition at this time. Instead, my modest amendment calls for a review into the issue. This would provide an opportunity to look more closely at the matter and consider carefully what changes could be made to the wording to ensure the legislation is as effective as possible. A great deal of work has already been carried out on this issue, and there's a wealth of views there to be considered already. And I hope, therefore, the Government will carry out that work and Parliament will support the modest Amendment 52 to enshrine the need for that work in legislation to complement my amendments 49, 50 and 51. Thank you.
Thank you very much. Mr Smith, I call Liam MacArthur to be followed by Finlay Carson.
Thank you, President Officer. I just want to record my gratitude to Colin Smith for his amendments in relation to the further protection of badger sets, as he rightly points out, bringing those penalties in line with the penalties already in place for harming badgers directly. The descriptions we've seen of suffocation that can occur through the tampering with a set are truly horrific and absolutely justify the approach being taken by Colin Smith in his amendments, which Scottish Labour Democrats will be supporting, albeit with the exception of Amendment 52. Thank you.
Thank you very much. And I call Finlay Carson.
Thank you. Notwithstanding our previous comments about the lack of concern about the sizable or growing level of badger persecution, and our understanding that persecution is limited to certain poachers and baiters rather than widespread. I welcome Colin Smith bringing forward this amendment to bring it in line with the penalties set out for other animals in this bill, so we'll be supporting his amendments.
Thank you very much. And I call on the Minister, Mary Goujon.
Thank you, Presiding Officer. These amendments cover offences relating to the disturbance of badger sets, and as I said when I was considering this issue at stage 2, I do appreciate the impact that offences involving the disturbance of habitats and resting places, including badger sets, can have on our wildlife. And that's why I also proposed at the outset of this bill to increase the maximum penalties for these offences to 12 months imprisonment and or a £40,000 fine, or both. However, I have listened closely to the concerns that have been raised by Colin Smith, as well as others at stage 2, and that's why I'm happy to support his amendments 49, 50 and 51 today, which will increase the maximum penalties for disturbance and destruction of badger sets to a maximum of 5 years imprisonment or an unlimited fine, or both, when tried by solemn procedure, along with the other most serious offences against our animals. Now, with regards to Amendment 52, I have to stress from the outset that this hadn't previously been raised as an issue, and consideration hadn't been given to that during stage 1 or 2. And I did have a conversation with Colin Smith regarding this. But the bill is about increasing the penalties for existing wildlife offences, and it doesn't seek to create any new wildlife offences, nor did it seek to change the definition of those offences. So it's coming so late in the bill process, we haven't had the opportunity to take any detailed evidence from stakeholders on this point during the course of the bill, or consult on any of these proposals. And because we haven't had the chance to do that or to consult on the issue, I'm not aware of the evidence which necessarily would suggest that that change is necessary. So therefore, before committing to undertake such a review, I would like to take some time to consider the matter further. And to that end, I intend to write to the Legislation Subcommittee of the Scottish Partnership of Wildlife Crime and the Scottish Animal Welfare Committee to seek their views on this matter. And with that, I would ask Colin Smith, if he's content with that, to withdraw his amendment, and I will provide him with an assurance that I will give careful further consideration to review once I've had the opportunity to explore this matter in more detail.
Thank you very much. And I would call on Colin Smith to wind up in this group and to press or withdraw Amendment 49.
Thank you very much, Presiding Officer. Can I thank the Minister and other members for their support on bringing penalties for offence against badger sets into line with those against the animal itself. I also welcome a willingness to look again at the definition of a badger set and consider whether any changes are needed. So on that basis, I won't press Amendment 52, but I know that commitment is on record, and I and many organisations such as Scottish Badgers, who have done some outstanding work to promote the study, conservation and protection of Scotland's badgers, look forward to working with the Minister on this issue in the future to make sure that we have a definition of a badger set to complement the changes in penalties. So on that basis, I won't move 52, but I will press 49.
Thank you very much. So the question is that Amendment 49 be agreed to. Are we all agreed?
Yes.
We are agreed. Can I call Amendment 50, Colin Smith, to move?
Move.
Thank you. The question is that Amendment 50 be agreed to. Are we agreed?
Yes.
We are agreed. Can I call Amendment 51, Colin Smith, to move?
Move.
Thanks very much. The question is that Amendment 51 be agreed to. Are we all agreed?
Yes.
And can I confirm that Colin Smith does not wish to move Amendment 52?
Not moved.
Not moved. We're going to turn now to Amendment 53 in the name of Claudia Beamish. This was debated earlier in the section on vicarious liability. Claudia Beamish, to move or not move?
Move, Presiding Officer.
That is moved. The question is that Amendment 53 be agreed to. Are we agreed or not agreed? We'll move to vote on Amendment 53, and this will be a 1-minute division. Members may vote now. 1-minute division on Amendment 53. The result of the vote on amendment number 53 in the name of Claudia Beamish is yes, 21, no, 58. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 54? Claudia Beamish, to move or not move?
Not move, President.
Not moved. Returning now to Group 8, Consideration and Protection of Marine Life. Can I call Amendment 29 in the name of the Minister? This is grouped with the amendments as shown in the groupings, and I would remind members to refer to the supplementary marshalled list for Amendments 55A and 55B. Minister, to move Amendment 29 and to speak to all the amendments in the group.
Thank you, Presiding Officer. The principal purpose of Amendment 29 is to enhance the conservation and welfare of seals by removing specific grounds for which Scottish ministers are able to grant licences to kill or take seals. The Marine Scotland Act 2010 allows Scottish ministers to grant licences authorising the killing or taking of seals to protect the health and welfare of farm fish and to prevent serious damage to fisheries or fish farms. This amendment will stop these provisions by removing paragraphs F and G of section 110, subsection 1, along with related consequential amendments. Other grounds for which licences are granted, such as scientific research, public health and safety, and conservation of seals, other animals and wildlife, are being retained. This amendment will also increase the penalties associated with the offence of killing, injuring or taking a live seal, intentionally or recklessly, in line with other serious wildlife offences. That is appropriate and proportionate with our approach elsewhere in the bill. This amendment will also align with measures taken by other countries, including provisions in the United States Marine Mammal Protection Act. And importantly, it ensures that we can still export farm fish to one of our most important markets, the USA, in the future. This market was worth £178 million in 2019. Therefore, this amendment will address welfare, conservation and economic concerns, and I hope members will support it. Presiding Officer, Amendment 31 in my name is a consequential change to the long title that would be needed if the Parliament agrees to Amendment 29, and I therefore move Amendment 29. Presiding Officer. Okay, I now turn to Amendment 29A in the name of Mark Ruskell. I've already laid out my reasoning for making changes to the Marine Scotland Act 2010, which are significant steps forward in ensuring the future welfare and conservation of our seals. Now, while I'm aware of concerns that some members have regarding acoustic deterrent devices, and principally in relation to their use within the aquaculture sector, I want to be clear that the proposed amendment isn't acceptable because it, in effect, bans the use of acoustic deterrent devices, and that would have far-reaching consequences for a range of activities within our territorial waters. Now, acoustic deterrent devices are regularly used within marine renewables, within oil and gas and coastal development sectors as a mitigation method to move marine mammals, including seals, whales, dolphins and porpoise, away from operations that could result in much more serious injury or harm to them. Furthermore, pingers, a type of acoustic deterrent device, are a mandatory requirement in some fisheries to prevent the incidental capture of dolphins and porpoise in fishing gear. So banning the use of these pingers through this amendment effectively bans the use of fishing gears in which pingers are a legal obligation. And while I absolutely want to do the best thing for Scotland's wildlife, we have to be mindful of the importance of these marine sectors to the Scottish economy, as well as the many livelihoods they support, particularly in our coastal communities. This amendment would expose marine mammals to a greater risk of being harmed through the operations of those sectors. And put simply, the proposed amendment is a blunt instrument seeking to address a nuanced issue, and it's because of that that I can't support it. And I would therefore encourage Mark Ruskell to withdraw Amendment 29A, as I don't believe the issue requires the amendment to the Marine Scotland Act 2010. I now turn to Amendment 55 in the name of Mark Ruskell and Amendments 55A and 55B in my name. Amendment 55 raises the issue of the use of acoustic deterrent devices by the aquaculture sector, which I do understand is a matter of particular concern to Mark Ruskell. Now, the Scottish Government is undertaking a comprehensive programme of work on this matter, including a review of the current regulation and management of ADD use within this sector. And it's my view that this review should be completed before determining what any next steps might be. The Scottish Government is currently supporting scientific research which will establish the full extent of current ADD use across the Scottish finfish sector. And furthermore, the research will underpin the development of robust science-based industry guidance and any regulatory reform deemed necessary on the future use of ADDs. I want to ensure that where EDDs are used, they're properly regulated and deployed to have effective deterrent effect while minimising any environmental impact and not unduly exposing marine wildlife to harm. And I suspect that that's the motivation behind Mark Ruskell's proposed amendment. So there is already a significant body of work underway in this important area, so much so in fact that I consider the amendment to be too narrow in scope to reflect that work, and it's for that reason that I've lodged amendments 55A and 55B to broaden it out. It's important that the national and international context that we're operating in is recognised, and my amendment places a duty on Scottish ministers to report on that broad framework. It's my view that Amendments 55A and 55B make the reporting requirement better reflect the breadth of work which is currently being undertaken by the Scottish Government, and I would welcome the obligation to report the outcomes to Parliament. So I can therefore only support Amendment 55 proposed by Mark Ruskell on the condition that Amendments 55A and 55B are accepted. Presiding Officer, I now turn to Amendment 61 in the name of Claudia Beamish. And I have to begin by reiterating what this bill seeks to do, and that is to ensure a consistent approach to the most serious wildlife crime, both on land and in our seas. If passed, the bill will rightly strengthen maximum penalties for offences against marine species, such as killing dolphins, seals and basking shark. Claudia Beamish's amendment would apply the maximum penalties being extended under this bill to offences relating to marine protected areas designated under the Marine Scotland Act 2010. Now, while I'm committed to properly and sustainably supporting our marine environment, there are significant problems with this proposed approach. And firstly, I have to begin by pointing out that this bill is concerned with increasing the penalties associated with the worst kinds of animal cruelty. This amendment, which pertains to marine protected areas, is arguably not in line with this, since it would apply to a range of activities which in some circumstances have little or no interaction or effect on animals. Indeed, currently it is possible to commit an offence under protected area legislation without actually harming animals and wildlife, and that is the case in relation to offences under Section 94 of the Marine Scotland Act 2010. So I don't think it's right to use stage 3 of a bill which is centred on animal welfare to increase the maximum penalties for a set of offences which can be committed without any actual harm caused to animals and wildlife. Secondly, I would say that this amendment pertains only to the Marine Scotland Act 2010, to the exclusion of other types of protected area on land and in our seas, and various pieces of legislation which underpin these important regimes. So in that regard, if accepted, it would create an inconsistent approach between different types of protected areas. And that would be undesirable and potentially unfair to marine users. So I hope members will agree that it's not the correct approach to single out just one type of protected area at this late stage, and in a bill which strictly is designed only to deal with animals and wildlife. Thirdly, we're already taking action to improve monitoring of activity in MPAs and to ensure compliance with MPA management measures. We're rolling out remote electronic monitoring, and Scotland's scallop fishing vessels have all voluntarily signed up to participate. And it's anticipated that all of Scotland's scallop dredge sector will have these systems by April next year. So that, I would suggest, will be a game changer in inshore fisheries management and in safeguarding marine protected areas. Taking action to prevent and deter illegal activity and offences will allow us to focus resource on taking enforcement action against the few who choose to break the law. And it's for those reasons that I cannot support the amendment, and I would ask Claudia Beamish to withdraw it. Thank you.
Thank you, Minister. I'm going to call Mark Ruskell to speak to Amendment 29A and other amendments in the group.
Thank you, Presiding Officer. For many years, the Scottish Greens and campaigners have been calling for an end to the brutal and unjustified killing of seals. So today we welcome that the Minister has finally brought forward a ban on the culling of seals, even if it comes at a very late stage, in stage 3 of this bill. A ban, though, on killing seals is only half of the action that is needed, because the use of acoustic deterrent devices arguably also falls foul of both the US Marine Mammal Protection Act's definition of harassment and also our obligations to protect seals, whales and dolphins from reckless disturbance under the Habitats Directive. A rise in the use of ADDs could be a direct unintended consequence of the ban on killing seals, and be in no doubt of the damage these devices could cause to dolphins. They've been described as acoustic torture and shown to cause severe and widespread disturbance. So I ask the question, why have the Scottish Government allowed a free-for-all in the use of ADDs on fish farms, which according to one study could be polluting over 12,500 square kilometres of our seas? Why is it that fish farms are not required to apply for licences by Marine Scotland for ADD use? And is that because Marine Scotland know full well that applications would not pass the licensing tests because there are clear alternatives for fish farms to protect their stock using tension nets and seal blinds, as they do in Shetland? Now, the Scottish Government's goal to double the economic value of the aquaculture sector is coming at an unacceptable cost to our environment, to the point that even the chlorine-washed US government believes we aren't properly protecting our marine wildlife. And that's why I'm moving Amendment 29 for a ban on the use of ADDs, specifically in the aquaculture sector, because as so often the case, we have to make a judgment in the absence of 100% scientific certainty. Given what's at stake, applying the precautionary principle and introducing a ban, we can be confident that damage is not being done to marine mammals and that we're not falling foul of both US and European laws. I expect this ban on ADDs, particularly conventional ADDs, to be coming soon. But I've listened to the comments that the Minister's made about the scope of the amendment, particularly in relation to pingers on fishing vessels, and as a result of that, I'll be withdrawing and not moving 29A. But I would hope that the Chamber will support Amendment 55 in my name, along with the manuscript amendments from the Minister, which require a timely report to Parliament on ADD use, monitoring and the implications for licensing. I am aware that there is already work underway to understand the use of ADDs, but there are urgent considerations that need to be brought directly to this Parliament before the US March 2021 deadline. Any changes to the licensing regime will need parliamentary time to approve, and I suspect we'll still be staring at the need for a ban on the majority of ADDs to rid our seas from noise pollution in 6 months' time.
Thank you very much, Mr Ruskell. I call Claudia Beamish to speak to Amendment 61 and the other amendments in this group.
Thank you, Presiding Officer. My Amendment 61 I think is a very important amendment that deserves the support of this whole chamber today because it applies a new maximum penalty to those few fisher people who are convicted of contravening a marine conservation order or offences relating to protected features of nature conservation MPA. And I did draw this narrowly, and I hear what the Minister's saying about other marine protected features, but I did focus particularly on marine protected areas in this deliberately. And as with the vicarious liability amendments, I am talking about those few vessels that operate illegally with disregard for these invaluable habitats and species. And I stress the word habitats as well as species because what is right for land is also right for our marine environment. And they are invaluable habitats such as mole beds and kelp areas and different places that are protected, as well as the actual creatures themselves, and that can do as much damage just as it can on land with the badger sets and the nesting and resting places, which the whole chamber has already agreed to pass. It's high time our sea creatures and habitats get the same respect and protection as those on land, and it's no less of a wildlife crime than the destruction of a hen harrier nest. The illegal damage of marine protected areas can mean the loss of precious habitats that took decades to establish and threaten the iconic biodiversity as well. And I understand what the Minister is saying about this is about wildlife, but they have to be able to exist within a certain habitat. The offences this amendment refers to are not overly punitive. They relate to serious damage and some clauses to ensure those who inadvertently cause damage are not disproportionately punished are there. I understand members may be concerned that this is the first time it was raised at stage 3, but it is actually analogous to the Scottish Government Seals Amendment in relation to this. And I did genuinely think before stage 2 about how I might say something about the marine environment, and I missed a trick. I should have thought about the Marine Protected Area amendment at stage 2, which I agree would have given more possibility of discussion, but I only thought about it after stage 2, and I do believe that the case is very strong. It is clear that the penalties issued in response to fishing in closed areas are inadequate as a deterrent, with multiple reports of illegally operating vessels in sites and illegal damage of to Gairloch by 2 vessels was widely reported in November 2018 and happened again a few miles north in Wester Ross MPA in July 2019. I want to thank Open Seas and the Sustainable Inshore Fisheries Trust for their support with this amendment, and Open Seas state that part of the reason for these repeat offences is in their view that the illegality is treated as a fisheries offence and not a wildlife offence, and part of the offence in the amendment includes the intentional killing or injuring of animals in a protected area, and it's hardly a stretch to state that this is committing a wildlife crime. The government guidance for penalties states, and I quote, "The level of fixed penalty offered will reflect any financial gain. Other factors which can be taken into account in determining the level of fixed penalty are whether the stock in question is identified by Commission as a recovery stock and whether the person has received a fixed penalty for the same category of offence." This clearly can't be right. It must be that it's about the effect on the habitat and wildlife concerned as well as what the value of the stock is. And I do recognise that the Scottish Government may think this is an issue that can be tackled by the rollout of the inshore vessel monitoring systems on the entire fleet. But progress on this has been and looks continuing to be quite slow. And also resources are stretched in Marine Scotland. To talk, as the Minister has highlighted, talking about doing these things in the round. The inshore fisheries bill has now been shelved, and we don't know when it will come, especially in view of COVID now. So in the light of the climate and environment emergencies, it would be very disappointing if the Scottish Government does not support this important shift in relation to marine wildlife crime, and higher penalties are a much needed deterrent to keep MPAs thriving. I want also to speak to support the Minister's amendment on seals, Amendment 29, though this did come to committee in 2018, so I'm not sure why we had to wait, but I think we'll just have to, we are where we are. But I hope it wasn't only because of the US demands that we're now in this situation where we're having to consider this, this amendment. But we will be supporting it today. Scottish Labour would have been abstaining on Mark Ruskell's Amendment 29A, but I understand that he's considering withdrawing it. But we do have concerns about dolphins and other citations, but for a number of reasons, I did have concerns. Fisheries Management Scotland briefing highlights the concerns about seals predating on wild salmon in our rivers. And it's not only about fish farms, as the Minister has highlighted, there's also wind farms and other installations. So in that context, I think supporting the Mark Ruskell's Amendment 55, making an obligation to report in only 10 or so months, March 2021, really makes sense. And as a way forward, let's really tackle this issue and see whether we should be banning them altogether or how we should be going forward on this. And it's unresolved and it needs to be tackled quickly. So we'll also support Amendment 55A and 55B by the Minister. Thank you.
Thank you very much, Ms Beamish. Can I call Finlay Carson to be followed by Edward Mountain?
Thanks, Presiding Officer. Firstly, we welcome the changes that have been brought forward regarding ADD. However, we are concerned, and it was raised at stage 2, at the lateness of the government bringing forward their amendments regarding the shooting of seals. Given that this had been, as Claudia Beamish had mentioned, been raised at committee before, and I think the research work had been first looked at way back in 2018, to bring it to the Chamber so late is not really acceptable, and it gives us little chance to look at the consequences of removing the ability to control seals in that way. The use of ADDs is obviously important. However, there's lots of elements we need to look at that as well. The use of the ADDs by the Scottish aquaculture industry is pretty much unregulated and largely unrecorded, undocumented, and we are concerned about the effect that these devices will have on, as we've heard already, porpoises, which are sensitive to underwater noises, and a range of other animals, including whales and dolphins. And we really should have been looking at that at stage 2, rather than bringing forward amendments at this stage. We've also got the issue, if we remove ADDs altogether, the potential impact on the wild Atlantic salmon and sea trout populations in our famed rivers, and protecting them from seal predation that the amendment brought in to shoot seals would have a huge effect on. We need to keep some sort of deterrence in our rivers to protect our salmon and our trout. So I do welcome that. We're going to do more work on that, and the amendments will hopefully address those concerns. With regards to Claudia Beamish's amendments, we're a bit concerned again that this was brought in at stage 3, and whilst Claudia Beamish and I have had discussions, it still makes it very difficult. Certainly.
Andy Whiteman.
Thank you, Member, for taking the intervention. He said at a number of occasions that amendments have been brought forward at stage 3.
Sorry, Mr Whiteman, your microphone doesn't seem to be on or down.
Apologies, Presiding Officer. thank Fianna Carson for taking intervention. He's mentioned on a number of occasions amendments coming forward at stage 3. Now, Oliver Mundell brought amendments at stage 3 in the Children Equal Protection from Assault Scotland Bill, Liam Kerr, many amendments in the Management of Offenders Scotland Bill, Dean Lockhart, Annie Wells, Graham Simpson on the Transport Scotland Bill. Is he saying that Conservatives have never, ever brought an amendment at stage 3 which has not been debated at stage 2?
Finlay Carson.
I'm quite taken aback, and I think this is probably getting in a strike first because he understands the displeasure there is right across the chamber at some of the amendments that the Greens have brought in at this late stage. I think the issue with it, there has been no discussion over the amendments that the Greens brought forward, none whatsoever, and it's more to do with virtual signalling and grandstanding than actually bringing in good law. I don't believe that's the case in Claudia Beamish's late amendment. I think she did what she thought was right at stage 2. We do have concerns because we don't want to inadvertently and disproportionately penalise our fishermen who might be potentially seen to be committing offences without actually damaging any protected animals. And I do believe that the progress the fishing industry is making with positioning technology, and that work should be allowed to continue, and we will see a dramatic increase in the responsibility of trawlers and whatever, and we will not see them being unfairly punished with the burden of proof currently lying with them. So we won't be supporting Claudia Beamish's amendment at this stage.
Thank you very much. And I call Edward Mountain to be followed by Liam MacArthur.
Thank you, Presiding Officer. And because Mr Carson mentioned wild fish, I'm just going to declare that I have an interest in a freshwater salmon farm. But that's not what I want to talk about. I think what's interesting is this discussion on acoustic deterrence. It was a matter that was brought up when the REC Committee did their aquaculture report. And it was we took evidence on this matter. And it was unclear, I think, at the end of it, that we knew how acoustic deterrence will work. So as a member of the REC Committee, I actually welcome amendments 55 and 55A and B, because I think this will shed light and actually close one of the issues that the REC Committee was looking at. If I could just say I'm also delighted that Mark Ruskell has withdrawn Amendment 29A. I think that is the right decision to make. My understanding is that acoustic deterrents have moved on considerably from where they were a few years ago, such that you can use detection methods to turn on an acoustic deterrent and only to use it to move an animal away when it moves into a danger area. God forbid, as far as I'm concerned, that some of the developments that we're carrying out in the Murray Firth, for example, should affect our dolphins that we enjoy so much within the inner Murray Firth, and therefore to use an acoustic deterrent to drive them away while pile driving work is carried out so that their hearing isn't damaged, to me seems a very sensible solution. So thank you, Mr Russell, for protecting the bottlenose dolphins that inhabit the inner Murray Firth. You've made the right decision.
And I call Liam MacArthur.
Thank you, Presiding Officer. I think the shooting of seals was perhaps one of, if not the most controversial issue that I and my colleagues on the then Rural Affairs Committee had to deal with when considering the Wildlife and Natural Environment Bill back in 2010. I believe at the time we made progress in restricting the practice, but it did very much feel as if we were on a journey, and that journey was far from complete. And so it's proved with the Minister's Amendment 29 today, which Scottish Liberal Democrats will be strongly supporting. At the same time, I was concerned to see Mark Ruskell's Amendment 29A. I remember during the passage of the Wayne Act that those advocating a ban on shooting of seals insisted that acoustic devices were perfectly adequate for protecting fish farms from seal attacks. I think, as the Minister has explained and Edward Mountain has just mentioned, the use is perhaps far more widespread than it was a decade ago. And I absolutely accept the point that there will be good acoustic devices and there will be those that cause unnecessary harm and we need to be getting rid of. So I welcome the amendment from Mark Ruskell in 55 and the amendments to that from the government. I think ensuring that the regulation we have of these devices is fit for purpose, so that we are weeding out the devices that really have no business being used, while still allowing for their use in appropriate circumstances, whether by those in the aquaculture sector or in other sectors where it's appropriate. So again, I thank Mark Ruskell for that amendment and for hopefully allowing us to make progress in an area that the current REC committee has clearly been giving quite a bit of consideration to over the past couple of years. Thank you.
Thank you. And can I call on the Minister to wind up in this group and on Amendment 29 in particular?
I'm happy that the amendments have had a broad support across the Chamber today, and with that I'm just content to move.
Thank you, Minister. Can I just confirm, Mark Russell gets to wind up in this group, just confirm though, do you wish to withdraw Amendment 29A?
I'm content to withdraw 29A. Yeah.
Thank you. So that amendment is, so does any member object to Amendment 29A being withdrawn? No. So we go to the next question, which is on Amendment 29. Can I ask the Minister to move formally? No, sorry, it already has been moved, yes. We move straight to the vote. The question is that Amendment 29 be agreed to. Are we all agreed? Yes. We are agreed, thank you. Can I call Amendment 55 in the name of Mark Ruskell? Mark Ruskell to move? Moved. That is moved. Can I call Amendment 55A in the name of the Minister? Minister to move? Moved. That is moved. The question is that Amendment 55A be agreed to. Are we all agreed? Yes. We are agreed. The question is that Amendment... Sorry, can I call Amendment 55B? Minister to move? Moved. That is moved. The question is that Amendment 55B be agreed to. Are we all agreed? Yes. We are agreed. Mark Ruskell to press or withdraw Amendment 55 as amended.
To press.
Thank you. So the question is that Amendment 55 as amended be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 61 in the name of Claudia Beamish? Claudia Beamish to move?
Move, Presiding Officer.
That is moved. The question is that Amendment 61 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a division on Amendment 61. This will be a 1-minute division and members may cast their votes now. 1-minute division, Amendment 61. The result of the vote on amendment number 61 in the name of Claudia Beamish is yes 21, no 59. There were no abstentions. The amendment is therefore not agreed. We're going to turn now to Group 9, which is programme requirements. Can I call Amendment 58 in the name of Claudia Beamish and Claudia Beamish to move and speak to this amendment?
Thank you, Presiding Officer. This amendment seeks to keep the issue of programme requirements for empathy training on the agenda. It enables a court to impose a programme, be it restorative justice or a rehabilitation programme, to develop empathy skills when a person is convicted of an animal or wildlife offence and given a community payback order. My thanks go to One Kind for their careful thought on this amendment and commitment to continued work on this issue. When considering appropriate cases, that does not include the most serious cruelty cases. Alternative disposals could be very valuable in preventing future offending and thereby helping protect animals. One Kind note that the Scottish SPCA Animal Guardians programme for children and young people who are starting to display offending behaviour towards animals is well recognised, as is the considerable amount of training available for adults on developing empathy, all focused on human-to-human interactions, which I won't go into today, but there are precedents for empathy training. I hope the Chamber will see the value in this amendment, but also be reassured that it's not too prescriptive at this stage, where there is more room for research, having discussed this with the Minister. I would welcome comment from the Minister on her intentions for this policy area in the future as well. And one kind also propose a possible Scottish Government-supported partnership to coordinate research into good practice in other countries and investigate the potential for a restorative justice clause going forward as an option for sentencing in this field of animal welfare and animal welfare crimes. Thank you.
Thank you very much. And I call Mark Ruskell.
Thanks, Presiding Officer. Just rise to support this amendment. It's very similar to amendments that are raised at stage 2. We've been in constant discussion with the Minister about the importance of empathy training. And I think it's important that this is backed up in legislation here today. I think every single member in this chamber will find offences against animals, criminality, as being absolutely repulsive. And I think it's partly because the victim has no voice. They're voiceless, and we rely on organisations like the SSPCA to represent those victims. But I think it's also important that we understand the root causes to a lot of this criminal behaviour as well. And some of it may come back to someone's upbringing, about whether they've been abused or bullied in their own life. So it's important that if we're rehabilitating offenders back into society to be safe around animals, that we proactively take the opportunities to do that. Because many of these offenders, they're abusing animals, but they may also extend that abuse to people as well. So it's hugely important that we adopt this restorative justice agenda, roll out proper programmes of empathy training in Scotland, and ensure that we can move forward.
Thank you very much. I call Finlay Carson to be followed by Christine Graham.
Thank you, Presiding Officer. We do support the use of a wide range of different targeted and imaginative measures, and we support the use of the payback orders and programmes such as the empathy courses, as referred to in the amendment. We believe that there may be resource issues in that, but that's something that we believe is a resource worth looking and investing in. There is international research which suggests there is a complex association between animal abuse, child abuse, and abuses of other vulnerable adults, and so on. So the lack of empathy is associated with violence and animal abuse. So I think this amendment is something we should look at, and is ensuring that those people, whether there are non-custodial sentences, for example, on community payback order, can get some training, but also the evidence that shows that time in prison also can result in a reduction in empathy. This sort of training could go a long way in ensuring these offenders don't reoffend.
Thank you very much. And I call Christine Graham.
Thank you, Presiding Officer. I rise in support of this amendment. I mean, some animal cruelty is deliberate. A vast amount is out of sheer ignorance. And what one wants to do with people who are ignorant in the true sense of that word and causing animals unnecessary suffering is to make them learn what they're doing to the animal and why they shouldn't do it. And another issue of this is children watch their elders. They repeat things that they see. So I think we talk about rehabilitation of offenders. Let's rehabilitate people, those that we can, who are unnecessarily cruel to animals, who simply not knowing the right thing to do at the right time with the right animal.
Thank you. And I call the Minister.
Thank you, Presiding Officer. This was an issue, it was raised at stage 1, and it was also thoroughly explored during the stage 2 debate, where it was agreed that amendments similar to that wouldn't be pressed, and it was something that I had committed to giving greater consideration to in looking at a non-legislative route. And that non-legislative approach I committed to is exactly what I've been working on, and that's why I'm very pleased to announce today that I've approved a proposal for a Scottish Government-funded research project to gather evidence on how empathy training training and related approaches have been used in other countries for the rehabilitation of offenders involved in animal welfare and wildlife crime. The research will consider available publications and involve discussions with the key stakeholders in Scotland on the feasibility of using or developing similar approaches here. And I expect the research to be commissioned in the next few weeks and the project to run for around 6 months. This research project also sits alongside £300,000 invested in the delivery of the Restorative Justice Action Plan, which was published in June last year, and additional funding being made available in the current financial year. It will complement the Scottish Government's existing vision of having restorative justice services widely available across Scotland by 2023, with the interests of victims at their heart. And I'm pleased to have the support of One Kind in this regard and look forward to the research involving them and other stakeholders such as the Scottish SPCA and criminal justice social workers. Now, I'm confident that this project will provide a more satisfactory basis to take forward any possible future development or provision of such courses in Scotland. And I believe that that can be done in a collaborative way with potential training for providers if the research suggests that this would be a worthwhile approach. So while I trust it is clear that I absolutely share Claudia Beamish's interest in this area, as well as other members across the Chamber, and thank her for raising this subject initially, I do believe that the non-legislative approach will be a much more productive way of taking this important area forward. And I would also point out that Claudia Beamish's amendment appears to have a fundamental flaw, and that it seeks to give courts a power that they do already have. And it's for all of those reasons that I would ask her if she would consider withdrawing her amendment.
Thank you very much, Minister. And I call Claudia Beamish to wind up and to press and withdraw Amendment 58.
Right, thank you, Presiding Officer. I've just been listening to what the Minister's been saying, and it's quite difficult because what I had tried to do was to frame an amendment which would have an enabling ability, so that when the research came forward, if there was evidence that this would be a possibility, that there was the legislation already there to enable the guidance. So I don't know if the Minister is able to sort of clarify why that's not acceptable.
Minister.
Well, that's the thing with the amendment, because it gives the powers to the courts that they do already have. So if we, as a result of this research project, we thought this was something that this was a specific approach we could take that would work in Scotland, and we were to develop some sort of courses, the ability for the courts to either decide to put people on these courses should they be found guilty of an offence, they already have the ability to do that. So that's where I do think that what we're trying to do here is establish the groundwork for that. I've already committed to it, as I say, and that's what we're looking to do. So I would ask the member if she is content with the approach that we've taken, and if on that basis she would be happy to withdraw her amendment.
Claudia Beamish.
Right, so that was a helpful intervention for which I thank the Minister, and on the basis of understanding better where the Scottish Government is positioning itself and taking forward that research with a view to, as I understand it, putting the possibilities into what already exists in terms of community payback orders, then I'm prepared to withdraw the amendment. Thank you.
Thank you very much, Ms Beamish. Ms Beamish wishes to withdraw the amendment. Amendment 58. Does any member object? No. Very good. We now move to Group 10. This is the review of requirements for additional offences. Can I call Amendment 59 in the name of Maurice Golden in a group on its own, and Maurice Golden to move and speak to Amendment 59?
Thank you, Presiding Officer. Amendment 59 relates to the requirement to conduct a general review of the provisions of the Act to ensure it is, in overall terms, sufficient to safeguard animal welfare and to protect wildlife. Animal welfare should never have an end point, but be something that we constantly strive to improve. In particular, but not exclusion, such a review should be required to consider the inclusion of pet theft as a specific offence, as well as following up on previous statements in Parliament to act against wearable electric shock training aids for dogs. Both these positions have received considerable support within and without Parliament from organisations such as the Kennel Club, the Scottish SPCA, One Kind and the Dogs Trust. A serious appraisal of both should be conducted. I've listened to the feedback from Stage 2 and thank Labour and Claudia Beamish for her and their support at that stage. The question facing the other parties now is, do you see a pet treated the same as an inanimate object, like a book, when there's a crime committed? Do you think it is acceptable to electrocute a pet in order to train them? Yes, happy to give way.
Mark Ruskell.
Can I thank the member for giving way? Absolutely back his amendments. But would he agree with me that actually one of the fundamental problems with this bill is that the scope is far too narrow? And a lot of the issues that he wants to see action on and I want to see action, we're finding it difficult to get them into the scope of the bill, to get proper scrutiny and to get progress from the government.
Maurice Golden.
Yeah, I agree with the member that the scope of the bill is very tight, and therefore on these particular issues I haven't been able to bring amendments that I otherwise would have done. So this is the best that we could do within the confines of the bill, and I would hope that everyone in the chamber would support this amendment and give an opportunity to test and strengthen the Act.
Stuart Stevenson.
Thank you for taking the intervention. And I look at this proposal for a specific offence of a theft of a pet. And I have a peacock that has been in our vicinity for the last 18 months. I do not own this peacock, and I have failed to find out who does. If I take this into my possession to address its welfare requirements, am I guilty of theft by finding?
Maurice Golden.
Well, that would be a matter for the courts to determine. And I'm sure the member would give a strong account of himself whether that were to come into place. I move Amendment 59.
Thank you very much, Mr Golden. Can I call Christine Graham to be followed by Claudia Beamish? Christine.
I feel like saying welcome back, Stuart. Beam me up, Scotty. I'd love to see the case in court where the peacocks brought in as a piece of evidence and asked if it was complicit. Now, I do appreciate that the commission is being set up, but I have great sympathy for this amendment because a couple of things here. The theft of a pet, I mean, we do know in law a pet is a piece of property. Nobody who has a pet ever thinks that. And the emotional heartache when it's stolen and the effect that there may be on the animal itself, as we now know, animals to the lowest level have sentience, makes the whole thing more horrific. But there's big bucks in this where animals are targeted and people don't find them for years. So I'm very sympathetic to the government looking at that. The second issue is electronic shock collars. I think before Maurice Golden came here, I was going on about these because at an SNP conference many years ago, maybe it was a Conservative that had the stall because they were giving us all electronic shocks. And they put one on my wrist to see it. I said, I'll do that. That'll not be a problem. I think it was about level 3 out of 10, and it was really, really sore. And that's when I became converted immediately to the nonsense of applying shock collars to dogs and indeed to cats or any other animal. And I say to anybody in here who has any doubts, you can put it on a part of your body that you choose, but I bet you'll then be against electronic shock collars. Because you do not train animals with pain. It doesn't even succeed. Many years ago, I had a radio debate with a farmer who was in favour of them. And he kept putting the electronic shock collar on his collie, and he said to me, because it runs under the wheels of the tractor that I'm doing is I'm looking after the dog. I said, you have to keep doing it. I have to do it again and again. What was the point? The animal was having pain, but it wasn't associating it with the wheels of the tractor. It might be associating it with something else round about, because the animal doesn't know why it's being done. So I think, and I note the rule of the Animal Welfare Commission, I may or may not support this because there's because it's 2025 before you're asking the review to report. But I think it's important to keep these items on the agenda as we now look more and more at the sentience of animals. So I'll see how it goes with the Minister before I make up my mind. I shouldn't say that. I've done enough breaking of the whip.
And call Claudia Beamish before I call the Minister.
Right, Presiding Officer, I'll be brief. We supported this amendment at stage 2, and I think it's appropriate in view of the range of issues that are very important that still need to be addressed in terms of animal cruelty in Scotland, that Maurice Golden in his stage 3 amendment has moved it to 5 years, and we're happy to support. Thank you.
Thank you very much. And Minister Marie Goujon.
Thank you, Presiding Officer. This amendment is similar to the one which the member lodged at stage 2. And while I note that the proposed timeline for the review has been amended, I still can't support it for a number of reasons, and many of those are similar to what I laid out at stage 2, but I will repeat them here. But I would outline that it's not because I fundamentally disagree with the points that either he or other members have made in the chamber today, because I agree with Christian Graham, it's important that these items don't fall off the agenda, and that is absolutely not the intention here. So, firstly, the amendment raises the issues of pet theft and electronic training collars, which I completely understand are matters of concern to members, because, of course, they're a matter of concern to me too. However, the proposed amendment just isn't necessary to ensure that those important matters are considered. Indeed, they are being looked at already and will be able to be pursued through the Scottish Animal Welfare Commission, which has now been established. Now, the Scottish Animal Welfare Commission will be able to consider a wide range of specific animal welfare issues concerning companion animals and wildlife, and can provide independent expert advice on how these should be prioritised and taken forward. And members will be aware that the regulations regarding the Scottish Animal Welfare Commission were accepted by the Environment Committee recently, and I really am excited by the prospect of having the... Oh, yes, I will.
Maurice Golden.
Merely to ask, Presiding Officer, if the Welfare Commission will cover this amendment and indeed review the issues raised within the amendment, then why wouldn't you choose to support the amendment?
Minister.
Because we're already doing that through non-legislative means. So, I mean, if you let me just finish these points here so I can further illustrate that. Now, the close and expert consideration of the issues which have been raised by Maurice Golden is exactly why the Scottish Animal Welfare Commission was established, and I think we need to allow them to do that work. And I would like to reassure you that many of the important improvements that I'm bringing forward in this bill have been developed through close and cooperative working relationships with those at the front line of enforcing this legislation, and through ongoing consideration of the operation of their powers. And I have absolutely no doubt that this will continue. So I would like to assure Maurice Golden that work on these issues is very much underway and will be taken forward. There's no intention that these will fall off the agenda, because of course they are vitally important. And I would ask that he considers withdrawing his amendment, because I don't believe the issues that have been raised require amendments to primary legislation.
Maurice Golden to wind up in this section.
Thank you, Presiding Officer. I've listened to the arguments from the Minister. I respect her passion for animal welfare. However, I think that there is a requirement to put in statute this review, because we've heard previously, not from the Minister, but from the previous responsible portfolio holder, that there would be, for example, a ban on electric shock collars, which we haven't seen. I think a review in statute is the only way that we can bind not this government, but indeed the next government of Scotland and of this Parliament to review both these matters and others. So I'll choose to press.
Thank you very much. So the question is that Amendment 59 be agreed to. Are we all agreed? We're not agreed. We'll move to a vote on Amendment 59. And members may cast their votes now. This will be a 1-minute division on Amendment 59. The result of the vote on Amendment 59 in the name of Maurice Golden is yes 42, no 37. There was one abstention. The amendment is therefore agreed. We turn now to Group 11, Information Sharing Report. Can I call Amendment 60 in the name of Colin Smith? And this is grouped with Amendment 62. Colin Smith to move Amendment 60 and speak to both amendments in the group.
Thank you, Presiding Officer. Amendment 60 in my name and its consequential Amendment 62 require ministers to produce a report on information sharing on animal welfare and wildlife offences. A number of stakeholders have raised this issue during the course of this bill, noting that the lack of information sharing on offences between relevant bodies and across geographical boundaries inhibited investigations and made it difficult to track offenders and identify patterns of behaviour. This issue was raised by the Environment, Climate Change and Land Reform Committee in their Stage 1 report, which concluded, and I quote, that information sharing on convictions may help track patterns of offending, including animal welfare and other forms of offending, such as domestic abuse and criminal activity. The committee recommended that the Scottish Government, again I quote, set up proposals to establish a registration system or a means of effectively sharing information between authorities. At Stage 2, I raised this issue with an amendment calling for the Scottish Government to bring forward guidance on the issue, with the hope that this guidance could be used to underpin the creation of a more effective and better integrated information sharing system. I didn't press that amendment, and I took on board the concerns raised at the time by the Minister at Stage 2. I've therefore suggested a different approach in my Stage 3 amendments. These amendments simply require a report to be produced on the issue within 5 years of this section of the bill coming into force. That report should set out what has been done to date and what steps the Government will make to take the matter forward. This will ensure that the issue is not forgotten again after this bill passes, and it will provide an opportunity for more detailed work to be done, identifying both the existing problems and the potential solutions. The Scottish Government have indicated that work is ongoing to address this issue and provided reassurances that they expect to make progress over the coming years. This amendment would therefore simply give this important work a statutory underpinning and introduce a greater element of accountability and urgency. I don't think anyone underestimates the various challenges over issues such as data protection when it comes to information sharing. But let's be clear, my amendment in itself does not have data protection implications, because it simply would commit the Government to bring a report on what action it plans to take to ensure that information is better shared. And I have no doubt that report will highlight any issues, and if these can be overcome, how they will be overcome. I therefore formally move Amendment 60 in my name, Presiding Officer.
Thank you very much. And I call Christine Graham.
Thank you, Presiding Officer. I am very sympathetic, but I'm not mad keen on reports on a 5-year basis. There's lots of other ways of holding the government to account, whoever or whichever government that is. You've got PQs, you've got debates. Committees at any point can call ministers before them to actually look at retrospectively how a bill is implemented. So I don't think this is necessary. I think it's actually an out. We should only come back every 5 years. Well, a lot can happen in 5 years, whereas through the other mechanisms within this Parliament, legislation can be evaluated. It should be done more often. The Audit Committee is already doing it. I'd rather see that than bind any government to have to produce a report every 5 years. There are better ways to do it. So I'm not supporting this one.
Finlay Carson.
Thank you, Presiding Officer. We are minded to support Colin Smith's amendment. It's important that a system of information sharing is in place, and right from the early stage of this bill, we've supported the idea of a central register in order for penalties and allow the various enforcement authorities easy access to these details. We've seen issues with fixed penalty notices between local authorities and the importance of information sharing. It was highlighted with that, and that will become even more important with the rollout of additional fixed penalty notices.
Thank you very much. And I call on the Minister.
Thank you, Presiding Officer. I just want to say from the outset that I absolutely sympathise with the aims of the amendment in principle, because the Scottish Government recognises the importance of improving information sharing and coordination between the various bodies who have a role in animal health, welfare and wildlife enforcement, including local authorities, APHA, Food Standards Scotland, the Scottish SPCA, Police Scotland, as well as others. Now, my officials are involved in ongoing discussions with enforcement bodies on this very subject, and I've been informed that there are current moves to standardise the databases used by Scottish local authorities and others, and to agree protocols for greater sharing of information between the various bodies involved in the wide range of animal health and welfare enforcement. So that includes many forms of information and intelligence that's not just limited to the outcomes of criminal cases as described in the proposed amendment. So again, while I support it in principle and am undertaking much of the work already, I do have serious concerns about the drafting of the amendment, which mean that I'm unable to support it. Firstly, the amendment does not specify exactly what information about those with relevant convictions should be shared. Secondly, it isn't clear who the information should be shared with or why such information is to be shared.
Claudia Beamish.
Thank the member for taking intervention. Surely one of the principal purposes of such an amendment as Colin Smith is to give some legislative framework, but not to be too detailed because of the commitment to go forward in the future and not tie anyone's hands.
Minister.
I would respond to that. I mean, we've talked about this previously when we had the debate about the vicarious liability amendments and how important some of these definitions are when they're in law. And I think especially when that comes to the likes of information sharing. And again, I'll come on to some more of that detail just now. So I've just outlined exactly what information about those with relevant convictions. It doesn't say who that should be shared with or what information could be shared. And it also isn't clear why that information is to be shared. So without that basic detail, it's difficult to understand what steps Scottish ministers should report on and what steps the Scottish ministers should take to further progress information sharing. So that, again, that clarity of legal expression is of the utmost importance. And that's particularly true when we're dealing with the use of personal information. So that leads me on to the other major concern, which is about the sharing of information regarding criminal records. So doing this could not only be regarded as interfering in matters that are properly for Police Scotland, who hold the criminal records of individuals, but it also raises difficulties regarding data protection legislation. For example, we're required to ensure that any personal data shared would be processed lawfully, fairly and in a transparent manner and collected for specified, explicit and legitimate purposes only. There's also the matter of human rights here. We need to consider whether any information sharing would comply with Article 8 of the European Convention on Human Rights, as this concerns the sharing of information about the private lives of individuals. Information sharing is a very complex area, so it's important that we take the time to fully understand the issues and consult with the relevant people. So because there is work ongoing and because this amendment is exceptionally unclear and because of the serious legal implications I've outlined, including with regards to human rights, it's unworkable and I cannot support it. So I'm happy to repeat the offer I made at stage 2 to have further discussions with Colin Smith on how the aims we share of improving information sharing and coordination between enforcement authorities in general can be progressed, but doing that more effectively in other ways that don't require a legislative approach. However, again, I would say that this amendment isn't workable or necessary, and I would ask if he would withdraw it.
Thank you very much. Now, Colin Smith to wind up in this section.
Thank you, Presiding Officer. The lack of information sharing on animal welfare and wildlife offences is a significant issue, and it's one that the Environment, Climate Change and Land Reform Committee, along with many stakeholders over a long period of time, agreed needs to be addressed. I'm mindful that this is a complex area and there are a range of technical and legal problems to avoid, but it's for that reason I did not pursue an amendment that could have any unintended consequences. What I've proposed in these amendments is more than a fair compromise which will ensure this issue receives the attention it needs and so far hasn't, without dictating any specific changes. Now, given the Minister has confirmed that the Government are working to make progress on this issue, there should be no problem in introducing some additional parliamentary oversight to this work through delivering a report to Parliament on the matter. The amendment allows 5 years from this section of the bill coming into force for this report to be produced, but that's at the latter end of the scale, and hopefully we'll see progress before then. The aim here is to give ministers, however, an opportunity to make progress on this issue before reporting on it and setting out future steps. I really do struggle to see how this could cause legal problems or impinge on human rights. The legal complexity of this area, in particular the challenges around data protection and instructing the legal system, are exactly why I haven't attempted to legislate on this issue directly within this bill. My amendment does not call for a specific course of action beyond a report on existing systems and any proposed government action, and it gives the Government a very generous 5 years to come up with that report. Christine Graham highlights that there are other ways to pursue this in Parliament, but the reality is, and many stakeholders have consistently said this, these other routes have not yet delivered what we want to see. Therefore, I will press what is a very modest amendment. As Claudia Beamish has highlighted, it's deliberately left general because there are a number of issues, but those issues should be addressed in a report to Parliament. Thank you.
Thank you very much, Mr Smith. And the question is that Amendment 60 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a division on Amendment 60. This will be a 1-minute vote on Amendment 60. The result of the vote on amendment number 60 in the name of Colin Smith is yes 41, no 38. There were no abstentions. The amendment is therefore agreed. We're going to turn now to Group 12. This is on additional protection for certain wild animals. Can I call Amendment 30 in the name of Alison Johnson, grouped with Amendments 56 and 56A? I would remind members to refer to the second supplementary marshalled list for Amendment 56A. Alison Johnson to move Amendment 30 and speak to all the amendments in the group.
Thank you, Presiding Officer, and I move the amendment in my name. I declare an interest as Deputy Convener of the Cross-Party Group on Animal Welfare. In normal times, many of the more than 23,000 people who signed my petition calling for protection for Scotland's mountain hares would have been with us in Parliament today. They would have rallied outside. They'd be filling the seats of the gallery. But I know from the incredible volume of support I've received for this amendment, and you will know too, colleagues, from the vast amount of correspondence you've received, calling upon you to support this amendment, that people across Scotland are watching and listening to this debate. I'd like to thank each and every person who's written in support, but I'd also like to thank One Kind, the League Against Cruel Sports, the RSPB and the Scottish Wildlife Trust for their support too. Now, in 2016, I joined a mass rally of folk outside the building, young and old. Outside this chamber, they came from across the country and they felt compelled to act when they learned about the indiscriminate, brutal slaughter of mountain hares in Scotland. They carried placards with photos of mountains of mountain hares dumped in the back of trucks. Their once white fur bloodied, their limbs mangled. Invited by organisers to speak at that rally, I committed to campaign until the slaughter ceased. The Cabinet Secretary for the Environment, Climate Change and Land Reform addressed the rally too, and she said that she too would act if she had sufficient evidence. Now, a year later in 2017, One Kind had to challenge the granting of government funds, so public money, via Visit Scotland to groups promoting recreational hare killing. And in March 2018, One Kind, the League Against Cruel Sports and Lush released a video narrated by Chris Packham exposing the shocking reality of Scotland's mountain hare culls. It aired on national television. Sadly, evidence aplenty. A balaclavaed, armed squad of quad bikers driving across the Cairngorms. Their aim? Apparently to shoot as many hares as they could. And we saw hares suffering injury and maiming, limping off, one caught by a dog in a drawn-out struggle. And I asked the First Minister for her views on this obscene activity, and the First Minister agreed that such slaughter is unacceptable. Well, it's now the 17th of June 2020. In between times, I've pushed on with my bill to better protect wild mammals in Scotland. I consulted for 12 weeks between the 12th of June and the 15th of September. And my consultation specifically asked consultees for their views on protection of mountain hares, exactly the specific amendment that today seeks to deliver that protection for this iconic mammal, and almost 10,000 responses were received, and 74% of respondents were supportive. And since last Thursday, I've just checked, and now over 23,000 individuals have explicitly supported this particular amendment. So it's hard to think of any other amendment here, or to any other bill, that's received such a mandate from the Scottish public. My amendment seeks to protect this the iconic mountain hare. It seeks to preserve a species in decline. A major academic paper published in August 2018 found that mountain hare populations on some grouse moors in the North East Highlands had declined by 99% since the 1950s. The authors concluded that intensification of game bird management has resulted in severe recent declines in mountain hare numbers. And in August last year, the Scottish Government reported to the European Union that mountain hares are now in unfavourable conservation status. Hunting and intensive grouse moor management were identified as key drivers of this decline. We can't continue to turn a blind eye to the ruthless and widespread persecution of this fabulous species. So voting for this amendment will end the killing and afford mountain hares the protection they urgently need. I am closing, but certainly.
Finlay Carson.
Just a simple question. Can the member let the chamber know why she didn't bring forward this amendment at stage 2 to give the committee the ability to scrutinise it fully?
Alison Johnson.
Yeah. the member will be aware that I have engaged wholeheartedly with the democratic process. All the organisations that you would expect to respond to this have done so in my consultation, which lasted for 12 weeks. I am entirely entitled to bring this amendment to the Chamber today, given the fact that you have received probably thousands of pieces of correspondence and that over 23,000 people in Scotland have responded to a petition about an activity that's taking place in this Parliament this afternoon. I would say that democracy is being served, Mr Carson. Colleagues, in closing, I will speak to in support of my colleague Mark Ruskell's amendments. They seek to better protect beavers in Scotland. In closing, I urge colleagues to listen to the people of Scotland, to vote to protect Scotland's mountain hares. Thank you.
Thank you very much. And I call Mark Ruskell to speak to Amendment 56 and the other amendments in this group.
Thank you, Presiding Officer. And can I offer my thanks and pay tribute to Alison Johnson? There are so many of us in this chamber that are species champions, but I've seen nobody more determined and driven to protect her species than Alison Johnson. And I think that comes over so much in the preparation work that she's done behind this proposal and her members' bill. Clearly, the lack of protection for the mountain hare is a bloodstain on Scotland's uplands. We have to restore this species to favourable conservation status. But in turning to my own amendments on beavers, I'm going to sound a warning for the way ahead, because granting European protected species status is just the first step on the journey to full protection. Beavers typify how nature can help tackle the climate emergency, a species that in the right place can slow water flows, create storage and restore habitat for other species. These ecosystem engineers are the absolute keystone species to the recovery of our river systems in an age of climate change. Now, we all voted for the beavers' protected status last year, and we all voted for a licensing regime where culling would be used as a last resort. But what I've seen in the fields around Strathern in the last 12 months is carcasses rotting, shot beavers floating to the mouth of the Tay. And out of a population of about 500 animals, nearly a fifth have been killed in those 12 months. Now, this makes an absolute mockery of the protection we were supposedly giving the beaver. And these cull figures, eventually prized out of the Scottish Government after they'd sat for months in an unpublished SNH report, are disgraceful. The beaver should be restored to favourable conservation status, but this can only be achieved by extending both its population and its range in Scotland. Land managers need to be part of the solution. They need financial help and support to manage beavers where possible, and to move them on to other locations where it is not. But at the moment, farmers and land managers cannot move beavers out of the area if there is a problem. The only option is to cull. There is sadly no alternative. Now, the Scottish Government is restricting the spread of the beaver, even though there are communities and landowners who would welcome them. And I perhaps invite Mr. Mountain perhaps come and walk with me and see some of these communities as well in our Balmorality. Until the favourable conservation status is reached, this iconic but vulnerable species, struggling to return from extinction, should absolutely not be being killed in Scotland. So my Amendment 56 ensures that a ban on culling, while the manuscript Amendment 56A that I'm also moving clarifies that further translocation under licence is still permitted. Now, I know that's a concern that the Minister shared with me. I've reflected on that. I brought forward a manuscript amendment. I'm grateful to the presiding officer for allowing that to go before the chamber this afternoon. I hope that will give government the confidence to now back this amendment.
Thank you very much. There are a number of members who wish to contribute in this group. I call Mike Rumbles to be followed by Brian Whittle.
Thank you, presiding officer. I want to concentrate my remarks on Amendment 30 in the name of Alison Johnson. Now, the Stage 3 process was originally designed to adjust legislation, adjust it, as a result of having evidence taken at Stage 1 and amendments to the bill debated and voted on at Stage 2, with evidence taken at Stage 2 if the committee wanted it. This final stage of the legislative process was intended as the last chance to fine-tune and adjust the legislation before, if successful, going to royal assent and into law. In my view, entirely new subjects, which this is, which have not been the subject of evidence sessions, should not be introduced at this last stage of the legislative process. That's my view. Unfortunately, Amendment 30 by Alison Johnson is just the sort of amendment which should never have been introduced at this final stage of the process. And why is that? Because if passed, we are very likely to end up with a bad law. Alison Johnson said that she had been campaigning about this since 2016, and I congratulate her for campaigning on this subject. But she didn't answer Finlay Carson's question when he asked why did she not bring this forward at stage 2. It would be quite appropriate for her to do so the committee could take evidence on this and we'd all be properly informed about what this issue was all about. All the evidence over the years, since I was first elected in 1999, that I'm aware of, means that if this misguided amendment is passed, Alison Johnson will achieve the exact opposite of what she wants to achieve. It will not protect hares on our... In a moment, I'd rather you listen to what I had to say first. It will not protect hares on our managed moors because the evidence, yes, the evidence shows that hares are more populous on managed moorland than unmanaged moorland. I know this sounds counterintuitive, but if members actually read the evidence sent to them by very many people, and just one of them being Alex Hogg of the Scottish Gamekeepers Association, who has huge experience in this area, amongst others, they will know this to be true. The Werrity report that found that mountain hares benefit from moorland management. Okay, yeah.
Alison Johnson.
Mr Rumbles will appreciate that I am entirely entitled to bring forward this amendment at this point. It is notable too that Mr Rumbles only seems to have a concern with this particular amendment. I have read the submission from the gamekeepers. It is quite remarkable in how it completely disregards the evidence that we have that population status is at 1% of that in the 1950s on some parts of the North East Highlands. I would also point out, of course they're going to thrive on grouse moors. We have stink pits, we have snaring, we have people shooting every apex predator that there is. And they may indeed thrive, but only if they're not shot in their thousands in a misguided attempt to reduce the transmission of a virus.
Mike Rumbles.
Well, I never at all said that the member was not entitled to bring this, so I don't know why she defends herself being able to bring it. I was saying it was a very unwise thing to do, and we should be... It is a very unwise thing to do. It's not how law should proceed in this system. We've got a proper stage 1 process, a proper stage 2 process, and stage 3 was meant to be about fine-tuning the evidence and the amendments that have taken for. This is not about fine-tuning. I said that the Werrity reports found that mountain hares benefit from moorland management. Other studies as recently as last year found that managed moorland remains a stronghold for mountain hares with the highest density of mountain hares in Europe. In a moment. The problem for Alison Johnson's amendment is that studies from areas such as Langham indicate that if the hare population explodes in the short term, which they will, there is an increase in disease and hares die in very large numbers. I don't want to see this happen. And I don't want to see a rise in the number of ticks and indeed Lyme disease on our hills. This unintended consequence will be the result if Amendment 30 passes, and I give way to Christine Graham.
Thank you.
Christine
It's
Graham.
just to reference to the Werrity report, which recommended that the shooting of mountain hares should be subject to increased legal regulation and licensing with improved evidence-based reporting of numbers. This is not a ban on culling hares, it is to license. There's a license regulation there in compliance with the Werrity report.
Mike Rumbles.
This amendment does not implement the Werrity report. There's no way it does so. And to pretend that it does, I'm afraid Christine Graham is egging the issue here. Presiding officer, I believe, all right, some members don't, I believe in taking and listening to the evidence in these matters. I don't believe in voting for an amendment like this, which is not based on science or the available evidence. We've made too many bad laws like this here, and I don't want to add another one. That's why I will be voting against this amendment.
Thank you very much. I call Brian Whittle to be followed by Stuart Stevenson.
Thank you, Presiding Officer. I think instinctively I couldn't imagine picking up a gun and shooting an animal. But it's also true to say that I've never had to manage a farm or manage any land, and I've never had to consider how to manage that land and manage the biodiversity. And in these matters, I would always seek out other expert advice. And the petition against culling of mountain hares was brought before the Petitions Committee while I was a member, and we did take extensive evidence from both sides, and as ever, both sides' evidence was rather weighted towards their own side, but the case for this ban on mountain hare culling was not convincing. Now, that's not to say that the debate should not continue, because it should. However, like others have stated, I think the way in which the Greens have shoehorned this amendment into stage 3 of this bill is not the way to effect change. So, as has already been said, where was this amendment at earlier stages? Stages where we could allow for evidence to be gathered and scrutinised by the appropriate committee. Evidence that may have allowed for opinions to evolve.
Johnson.
No, I thank Mr Whittle, and also for pointing out that this issue has been discussed in Parliament by the Petitions Committee, amongst others. But does Mr Whittle share the same concerns about other amendments that have been voted on this afternoon that came forward at stage 3, or is it just this in particular?
Brian Whittle.
I think you'll find that these other amendments have been discussed prior to this at earlier stages. And this is the one that you have actually shoehorned in, and you've thrown it in as an afterthought that in truth I think threatens the overall bill. And this is a bill that contains some very important legislation. If it was so important, where were any of the Greens during the evidence session in the Petitions Committee? You have had ample time to question witnesses and make your points. And as has been said already, I think, quite frankly, you're opportunists and you're grandstanding, which does the good work of this bill no good whatsoever. And nearly all of these petitions that have come before the Petitions Committee, including petitions such as the raptor persecution one, it seems to me the problem is about enforcing the law as it stands, rather than creating new law. That is what we should be considering. How we better prosecute those who break the law, not penalising those who lawfully work the countryside and maintain the countryside. I will be voting against this amendment this afternoon.
Thank you. Stuart Stevenson, to be followed by Edward Mountain.
Thank you, Presiding Officer. I think the one thing in this debate we might all agree is that we all want a healthy and sustainable population of mountain hares. But the process by which we get to that via this amendment is one which causes me considerable concern. I commend Alison Johnson's efforts on this, her support for some years on the subject. She referred to the completion of a consultation on the 15th of September last year. Curiously, that is a mere 15 days before the publication of the bill that is before us. It would have, to me, seemed a sensible, rational way of progressing my support for mountain hares to have brought that forward as part of the committee and Parliament's considerations on this subject. Not yet, maybe later. But it is not a question of the evidence in favour of supporting mountain hares in the way that Alison proposes. It is also a question of testing the counter-arguments which might refine the approach to supporting mountain hares. Those arguments have not had an opportunity to be put by the use of the process that is before us today. I will give way, if I may, to your colleague first, since she asked first.
Alison Johnson.
Yeah, I'm wondering at what point Mr Stevenson feels that the counter-arguments to Amendment 29 on seal culling, which he voted for earlier today, were tested in that way.
Stuart Stevenson.
It's not as if seal culling is a subject in which I have not previously been engaged. Indeed, in 1968, when I was a water bailiff, it was an issue for me working for the Tay Salmon Fishing Board. So this is not new. And I have made comments in this Parliament on seal culling before. I have, however, the key point is, why did the member not use what ought to any sensible consideration of the interests of mountain hares consider that only 15 days after the completion of her consultation, a bill that created the opportunity, she recognises that so by bringing forward the amendment today, why did she not put in there? I think that is the abuse of parliamentary process, which is causing us a number of concerns. It does not necessarily mean that I'm turning my face away from the rights of mountain hares. I absolutely support the rights of mountain hares. But I do think that in future it would be useful if the member and her colleagues were to use all the parliamentary opportunities that there are to progress a point of view that she espouses so passionately. She has signally failed to do so in putting on the statute book as a protected species Lepus timidus. Timidus, translated from the Latin, has 5 meanings: timid, cowardly, apprehensive, and without courage. These are words which might be applied to the process that got us here.
Lord Mountain, to be followed by Claudia Beamish.
Thank you, Presiding Officer, and I apologise if I am going to be slightly long in my response, but I want to respond to both amendments. And before I do, I would like to refer members to my register of interest in that I have a farm. There are no blue hares on it, and I have an interest in a river, and there are no beavers on it. Maybe one day. I also come to this Parliament having spent 40 years of managing habitats across Scotland. I want to talk about farming, if I may, just first before I move on to hares. You'll see the link. When it comes to farming, farmers manage habitats to achieve the goals they want to. When it comes to the farm, we manage our soils. We make sure there's not low fertility. We make sure there's not bad structure by making sure that straw and manure is used, and we make sure they're not too acidic. And when it comes to grazing pressures on that farm, we make sure that our cows and sheep on the farm match the capability of the farm. There are some examples I could give you where a field may support 40 cows for the summer. It can't support 35 because the field will be undergrazed and the grass will go rank, and it will therefore adversely affect the output. And it certainly can't affect 41 because it will be overgrazed. So the decision you have to make is to match the habitat that you have got. And now, turning to moorland, that is exactly what we have to do. But the problem is that we can't, and rightly so, under good environmental practice, manipulate the soils because we don't have them. We have peat, and peat can come in different forms, not only the narrow levels of peat, it can be deep peat, it can be wet peat, it can be boggy peat, and we can't manipulate that, and nor should we seek to. But what we have to do, therefore, is manipulate the stuff that is on the peat, and there's 2 ways of doing that. First of all, and I want to give you an example, if I may, of a particular area that I took on the management of some years ago. The low ground, calcareous grassland, was bitterly overgrazed and was unproductive. The middle ground, the heather ground in the middle, was rank heather, which had a peaty mass that prevented any growth. And the upland was overgrazed. So the only way to do that was to manage the mouths on the hill. And so we had to work out through overgrazing how we'd stop that. So the first thing that we had to do was take off 1,000 sheep, which went to market. We then had to take off 800 deer because there were too many of them. And I'll be interested when we come to this deer debate that we're going to have later in the year and the proposals that are up and supported by many parties, which increase the length of the hind culling season. Because by doing that, you are meaning that hinds will be culled carrying calves which have to be euthanized after the hinds have been culled because they are viable. And if I took cattle to the market in that state, I would be prosecuted, and rightly so. So think carefully when we come to deer. But we have to manage them, and we remove them. And we had to manage the hares because they were overgrazing the upper high ground, and we removed 400 hares. And the final component that had to be removed was the biggest component of the lot. And that were the rabbits that had spread all across the calcareous grassland and were decimating it. And over a period of time, we removed 10,000 rabbits from the low ground. Many of them went off to market, some of them couldn't. But we kept the pressure up, and the moorland started to come back. But we also had to do one other thing, which was to do some heather burning, something that many people in this chamber frown at and say it's not right. And it's used for only one purpose. But the reason why we did the heather burning was to remove the mat. Now, what was the point of all this? Some of you will be sit there thinking that this was all done for grouse shooting. It wasn't done for grouse shooting. It was done, and I'm very proud to say that I was part of a group that established 1,000 acres of native Caledonian pine woods in the Cairngorms with birch and aspen. That was a huge achievement and something that I'm proud of. Now, that could not have been achieved without the culling that's required. And if you don't believe me, look at SNH, go to Craig Magee and see what they've achieved there with the trees that they've grown. And that has only been achieved by culling hares and culling deer as they moved in. And that is why licensing isn't really that responsive. Because as the snow closes in and the hare get forced into the area of... Sorry, did you want to make an intervention? I'm very happy if you'd like to make an intervention. If you don't, I'm happy to continue. But the licensing problem is that the snow forces the hares in and you need to kill them there and then to prevent damage to the trees, which can happen in a series of days. So I don't think that a hare ban is the right way forward. It doesn't protect Scotland. And in my opinion, with 40 years' experience, I would say to you that by banning the control of hares, you are hastening their demise. Now, Presiding Officer, I'm sorry to go on, but I want to talk briefly about Amendment 56 and beavers. Presiding Officer, you will remember, as everyone in this Parliament will remember, that there was a trial reintroduction of beavers which was undertaken in Knapdale Forest. This was scientifically done. And it was to inform the government's position prior to a national conversation about the reintroduction of beavers across Scotland. Unfortunately, due to wildlife crime and the illegal reintroduction of beavers into Tayside, beavers spread out and jeopardised all the work of that trial. That is not helpful, and it's certainly not the way we should be dealing with reintroduction of species. This population in Tayside has naturally spread out. And Mark Ruskell, I'll take you up on your effort any day to go and walk looking at beavers. And I'll tell you what, in the afternoon, come and walk with me with some farmers whose grade 4 arable land has been destroyed because beavers have blocked all the drainage pipes and that no crops can be grown on it. Now, I also welcome the work that the Cabinet Secretary, Rosanna Cunningham, has done on this. And I welcome the management plan that she put forward in front of the ECCLR committee. And I actually supported that. I went along and listened to it. And Cabinet Secretary, I think that that was a useful debate and a useful management plan. The problem is we don't know if it's working. What we need to do is to give that time. But what we do need to make sure doesn't happen is the human translocation of beavers happening outside the areas that they're already in. That is not helpful. Maybe beavers can spread out and do it themselves, but humans have actually been picking up beavers and moving them to an area outside their thing. Mr. Ruskell.
Mark Ruskell.
For giving way. I thank the member for giving way. Would he not accept, though, that translocation done under licence legally is acceptable?
Edward Mountain.
You know, that's a decision for the Cabinet Secretary to make under the management plan, but what you are suggesting is that no culling of beavers could take place. Now, you know, having been involved in management across Scotland, Mr. Ruskell, I know how much money this government has pumped into trees and re-established riverine habitats. You know, the Cabinet Secretary, Mr. Ewing, has pushed and pushed and pushed, rightly, the reintroduction of trees and rightly the introduction of native species to create habitats. It would be a pity if all these are destroyed. So therefore, I cannot support an amendment that would prevent the removal of beavers that are problem beavers. Because, and I just want to give you this example, and it's in response to your comment, Mr. Russell, about beavers building dams and creating berms for water to be stored in the catchment. Just imagine a series of baths, if you may, 3 baths in a row. And every time one bath fills, it fills the next one. That's what happens when beavers dam a river. So you get a series of dams and they're all full of water. The first thing that happens when the rain comes along is the water comes whooshing out over the top because there's nowhere for it to go, usually breaks the dam and causes a massive flood. So, for these reasons alone, Presiding Officer, I cannot support either the amendment on hares or beavers, because I think they will damage the species that in many ways I seek and have sought all my life to protect.
Thank you very much. I call Claudia Beamish to be followed by Murdo Fraser. Claudia Beamish.
Thank you, Presiding Officer. I want to speak in support of Alison Johnson's Amendment 30. I believe that the time has come to properly support and protect the mountain hares, and Scottish Labour is clearly and absolutely against the mass culling of this species, and it is clear that this should only be done under licence where it is necessary and where evidence has been presented. This is highly relevant to the future of our Scottish uplands, and especially in relation to some driven grouse moors. And I think that I'm not going to say any more about that. Time is moving on, and we are supportive. We are also supportive of Mark Ruskell's Amendment 56, and I simply want to say on that I've listened to what Edward Mountain said, but I do have to say that with the possibility of the translocation under licence that Mark Ruskell is highlighting in his manuscript amendment, this would be a properly managed process and would prevent the culling of a protected species, and it would have to be that whether under the Habitats Directive, the EU Habitats Directive, the beavers were in favourable or unfavourable condition as to how this was taken forward. I think it's important in relation to climate change issues. I'm about to finish, but I'm happy to take an intervention, yeah. I think it's important also in relation to climate change issues that the contribution that beavers can make, yes.
Edward Mountain.
It's just the point, if you look at the amendment that Mr Ruskell suggested, that the only way that the culling of beavers could take place if they were favourable, the status was favourable across all of Scotland. So that would mean if you had beavers favourable in Tayside and no beavers in Deeside, they couldn't be favourable in Scotland, so no culling could take place. That is another significant flaw in the amendment.
Claudia Beamish.
Right, well, I was about to finish, and perhaps Mark Ruskell has a comment on that, but I actually think that they would only be translocated to places where it's appropriate for them to be translocated to, if that's clear. So I'll end my remarks there and say that Scottish Labour is supporting both those amendments.
Thank you very much, Ms Beamish. I call Murdo Fraser to be followed by Liam MacArthur.
Thank you, Presiding Officer. I'm going to make quite a brief comment, if I can, on amendments 56 and 56A from Mark Ruskell on the issue of beavers, because all members who represent the Tayside area are familiar with the large, active and growing beaver population around the rivers in the Tay, the Erne and the Isla. And this is a population that's grown from nothing to 500 over the last 2 decades or so. Now, I think we need to put this in context. This is a bill we're looking at about wildlife crime. The Tayside beavers exist only because of a wildlife crime, the illegal release into the wild of an animal at that time which was an alien species to Scotland. And nobody has ever been arrested for that crime or charged with that crime, far less prosecuted or convicted for that crime. So in the context of this bill on wildlife crime, I think that's a very important starting point for the discussion. That said, I agree with a lot of what Mark Ruskell said. The beavers are generally a welcome addition to Scotland. In my view, they are good for biodiversity. They are even popular with tourists. People like to see the beavers. But the beavers are not an unqualified good thing. Not everybody loves them. They do, as Edward Mountain said, they do damage to riverbanks. They undermine natural flood defences. They gnaw down trees. They are responsible for the flooding of low-lying, productive agricultural land in places like the Strathmore Valley. And therefore there is a conflict between people who are conservationists and environmentalists and are pro-beaver, and farmers who think they're a pain in the backside. who are causing them a lot of problem. And when we had this debate, which went on for years, about what to do with the beaver, there was an argument, quite a strong argument, put forward by the farming lobby that because the beavers had been illegally introduced, they should be eradicated and removed entirely. Now, the Scottish Government, in fairness, worked very hard to find a balanced solution to this, and in 2019 came forward with what was the result of a great deal of work and consultation. And this said that beavers would not just be tolerated, but actually given protected species. But the quid pro quo for that was very important, because the quid pro quo was that farmers and land managers would be given the right to control beavers in areas where they were causing damage to agricultural land. And the problem I have with Mark Ruskell's amendments is that they ride a coach and horses through that very balanced and sensible approach that the Scottish Government arrived at after a great deal of hard work and consultation and negotiation and discussion. Now, Edward Mountain pointed out this a second ago. This amendment actually makes no sense at all. It talks about the favourable conservation status of beavers, but we know we've got a large and growing beaver population in Tayside, but there may not be beavers in other parts of Scotland. So how are we going to assess what the conservation status is? In Tayside, there's lots of beavers. In many areas of Scotland, there are none. On that argument, you couldn't remove any beavers from within Tayside because they didn't exist elsewhere in Scotland. And as other members have said about other Green Party amendments, this has been introduced at the last minute. There's been no consultation, there's been no engagement with stakeholders, it's not been properly thought through, it's just a publicity stunt introduced at the last minute and at the last point in the parliamentary process. So I would encourage members to reject these amendments from Mark Ruskell. But have no fear, Presiding Officer, because the Tayside beavers will continue to thrive. The numbers will continue to expand, as they have done over the last 2 decades. The population will grow. It doesn't need Mark Ruskell's grandstanding to protect the Tayside beaver.
Thank you. I call Liam MacArthur to be followed by Liam Kerr.
Thank you, Presiding Officer. Well, as we've heard, there's been understandable disquiet about various amendments to this bill parachuted in at stage 3 by the Green Party without any scrutiny at stage 1 or stage 2. This has become a hallmark of the Green Party playbook, and however well it might play with supporters, it does show a cavalier attitude for making good law, particularly in a parliament without a revising chamber. That said, I readily acknowledge the considerable amount of work that Alison Johnson has put in over the years in relation to the issue of mountain hares. She has argued her case with tenacity, seeking to convince members of the need for further action to protect the hare population in Scotland. Even those who have disagreed with her position would, as I think we've heard again this evening, at least recognise the commitment she's shown to delivering change. Scottish Liberal Democrats will support her Amendment 30 this afternoon, but share some of the concerns expressed, not just about the process referred to by Stuart Stevenson and Mike Rumble, but also, importantly, about the effect. In a situation where we still don't fully understand the effects, for example, of tick burden or of population density, it's clear more work needs to be done, even in the event, as seems likely, this amendment is passed by Parliament this evening. It will also be important to ensure that the licence scheme referred to by Christine Graham and earlier intervention still enables measures to be taken where appropriate to control disease or prevent serious damage to agricultural land that Edward Mountain, Murdo Fraser and others have rightly highlighted. I'm confident that that work can be done, and on that basis can confirm our support for Amendment 30.
Thank you very much. And I'll just say to colleagues that as we are nearing the agreed time limit, I'm prepared to exercise my power under Rule 9.8.4a to allow the debate in this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. Liam Kerr to be followed by Christine Graham.
Presiding Officer, I'll be suitably brief. I have a deep disquiet about the process behind Amendment 30. Like many MSPs across the Chamber, I made sure to read the huge number of representations we've received from those in favour of preventing mountain hare culls and from those against, so I would be as informed as possible. And I can see from those representations that if this amendment passes, the consequences could be huge. Those in favour say that is to the good and will protect mountain hares. Those against say it could be a disaster, will lead to proliferation of ticks and Lyme disease, and ironically could have a negative impact on the hare population. Who is right? I don't know. And this is the problem, because the banning of any practice, particularly one that has been around for such a long time, needs very careful consideration and a forensic analysis of what is being proposed, what the correct balance might be, what the wider implications will be. But we have not done that. Now, during the COVID-19 crisis, there has rightly been much talk about pursuing evidence-led, science-based approaches. Yet this amendment is brought forward today without being scrutinised by the relevant committee at stage 2. A committee which presumably could have heard from expert witnesses, could have scrutinised the Werity Review and sought a government response to it, could have taken advice from Scottish Natural Heritage. Instead, we vote now in a unicameral parliament which has dispensed with that key scrutiny stage. So MSPs will decide whether to vote for or against this amendment based not on a committee's interrogation of facts and expert scrutiny, but on our pre-existing views and hundreds of emails we've all received, which take fundamentally opposing positions. So, will this amendment stop mountain hare culls? Yes. Will there be a negative impact on hare health and numbers in the medium or long term? I don't know. But some who know a lot more about this than me say yes. Will it result in negative wider consequences and a massive increase in Lyme's disease-bearing ticks? I don't know. But those involved professionally say yes. And just in case they are right, and to ensure the public has confidence in our system, I ask Alison Johnson not to press this amendment and instead bring it forward separately in its own right to be debated and to be scrutinised. And if she does press for MSPs to vote against, that is how to ensure proper scrutiny, that is how to make good law, and that is how to protect mountain hares.
Christine Graham, to be followed by the Minister.
Thank you, Presiding Officer. I'll be brief because it's a late time at night. I very much support Alison Johnson's amendment. With regard to Mark Ruskell's, I support the spirit. I want to hear what the Scottish Government has to say about the technicalities that I've heard the opposition dealing with. Although, again, it's licensing. And the business about the hares isn't that they're preventing culling in its entirety. Licensing will have to be observed. I think that has to be made clear. And I quoted from the Verity report already to the member. The Joint Nature Conservation Committee of 2019 report to the EU for the period 2017 to 18 categorised the mountain hares in the UK as being, in quotes, an unfavourable, inadequate conservation status, and the term inadequate referring to lack of data. All this in addition to the animal welfare concerns. Shooting hare is notoriously challenging, as they are small, fast-moving animals and the shooting takes place in an environment where plenty of cover is available. This heightens the risk of injury rather than clean kills. Furthermore, commercial hunts may involve hunters with little experience, adding to the risk. And as shooting is not licensed activity, there is no welfare monitoring or reporting, making it impossible to know the scale of the suffering. After shooting, many hares are not eaten but are dumped in stink pits, which I've talked about here before, as waste. So this is a licensing regime, not an outright ban. That's the thing we have to remember in this particular instance. I see no harm in a licensing regime where genuine containment and reduction in the hare population is required, but not just a free-for-all, as seems to take place these days. As for the Beaver Amendment, I wait to hear what is said by the member and also what the government says. There do seem to be technical difficulties. Thank you for calling me.
Thank you, Ms Graham. And I call the Minister, Marie Goujon.
Thank you, Presiding Officer. I mean, again, I have concerns about the process of this. I'm not going to rehearse and go over all those arguments because I think that's been raised adequately by other members across the chamber today. And again, at the same time, the Seal Amendment has been raised. I accept the criticism for that, accept the criticism that was given to me by Finlay Carson earlier during the discussion on that. But obviously, that wasn't an ideal situation, but we did try to get that information to committee to give them even a limited chance to scrutinise it as much as we possibly could, and regrettably that hasn't happened here. Now, the Scottish Government has always maintained that large-scale culls of mountain hare are not acceptable if they threaten their conservation status. And that's why we were the first country in the UK to introduce a closed season to protect both brown and mountain hares during the breeding season. Now, it's also why we commissioned the Independent Grouse-Moor Management Group, led by Professor Werity, to look closely at this issue as part of their remit. Now, the group examined the environmental impact of grouse moor management practices such as muir burn, the use of medicated grit, as well as raptor persecution, and advised on the option of licensing grouse shooting businesses. Now, its members were experts in environmental research and environmental law, conservation and land management, and they spent a year taking evidence and visiting estates. Now, I firmly believe that this consultative and evidence-based approach is the best one. And while the Scottish Government is still to formally respond to the Werity report, it does contain a number of important recommendations relating to mountain hares, which I am mindful of today. Presiding Officer, I believe that it would have been better for members to wait until we have had the response to that report in full before suggesting legislative changes, rather than seeking to lay a preemptive amendments at stage 3. Now, as members will be aware, I represent a rural constituency, and I completely understand and accept that in a variety of circumstances, it is essential to control hares as well as other species. For example, to protect new trees, manage grazing impacts and mitigate the spread of disease. Now, I also know that for many of those who undertake these activities, they care deeply about Scotland's countryside and its maintenance. However, I'm also mindful of the concerns that are being shared by many, that mountain hares are currently in an unfavourable, inadequate conservation status, and that there is a very real concern among some stakeholders and members of the public over the number of hares that are killed each year. The mountain hare is a priority species for conservation action under the UK Biodiversity Action Plan, and it's also on the Scottish Biodiversity List, which means that it is considered to be of principal importance for biodiversity conservation in Scotland. Now, on the issue of numbers, I would like to acknowledge the work being undertaken by Scottish Natural Heritage in conjunction with the Game and Wildlife Conservation Trust and those involved with land management to develop and deploy practical methods for estimating hare densities. Presiding Officer, I have given this amendment a great deal of thought, and in the short time that was available to me, I sought to gather views. I've been inundated with correspondence about this, as I know every other member across this chamber has been. I've read all those points and I've considered them very carefully. One of the most important points for me to understand was, if hares are to become a protected species, how any proposed licensing scheme would operate in practice, both with regards to how it might help prevent large-scale culling of mountain hare, but also, crucially, how it would allow those with legitimate management responsibilities to continue that work. Presiding Officer, this amendment would mean that there would no longer be an open season for mountain hares. Control of their numbers would need to be done under licence all year round for permitted purposes, such as preventing serious agricultural damage, protecting timber and preventing the spread of disease. Now, on balance, and notwithstanding our concerns about the late lodging of this amendment, the Scottish Government has decided to support it. I'm content that this move strikes an appropriate balance between the interests of those involved in legitimate land management and protecting an iconic Scottish species. But having said that, as I've already alluded to, I'm not happy with the manner in which this amendment has been advanced. Therefore, while I intend to accept the amendment, I will be giving careful thought to how any proposed licensing regime will work and when the protection will come into force, because there are still many issues we need to tease out. I intend to discuss this in detail with stakeholders over the coming months as part of a proper consultation process. Now, turning to Mark Ruskell's amendment on beavers, another addition not previously discussed at any stage of the bill process and submitted at the very last minute. And indeed, the manuscript element of this amendment just yesterday was just 24 hours before this stage 3. And I have very serious concerns about the impact that both of these amendments could have. Mark Ruskell's Amendment 56 would require Scottish ministers to be satisfied through the licensing body, Scottish Natural Heritage, that the beaver population is in a favourable conservation status before being allowed to issue any licences for any purpose. Under the current licensing regime, which was reached by the Government after a process of wide and inclusive consultation, and which, I have to remind members, has only been in place for 1 year, SNH can issue licences for a number of actions, including ringing or marking animals or introducing them to particular areas. Now, this amendment would not only prevent SNH from issuing licences to control beaver numbers, it would also stop them from issuing a licence to relocate or even tag beavers. So it would mean that we would have no non-lethal options to deploy when beavers' dams create large-scale damage to prime agricultural land, and we would have no options to assist in studying their behaviour as part of monitoring welfare. So for those reasons, I cannot support that amendment. But turning now to Amendment 56A. Now, while the Parliament has only had 24 hours to consider this, I'm clear that there are still fundamental problems with it. Presiding Officer, Amendment 56A would prevent SNH from issuing a licence for lethal control for any purpose if beavers were to be found to be in unfavourable conservation status. Now, as I'm sure will be of particular concern to members, Mark Driscoll's Amendment 56A would severely constrain the options to intervene in beaver populations where necessary as a matter of public health or should a disease break out among the beaver population. This poses dangers to the public just as it does to the species. Now, the Scottish Government has always maintained that beaver should only be killed as a last resort, but that it's essential we retain the ability to take actions, including undertaking lethal control, particularly when it concerns matters of public health or disease control. Now, I'd also like to point out that Conservation Natural Habitats Regulations 1994 already provide that Scottish Natural Heritage cannot grant a licence for anything to do with beavers unless A, there is no satisfactory alternative, and B, the action authorised will not be detrimental to the maintenance of the favourable conservation status of the species. The existing law is therefore already framed in a way that ensures SNH do not issue licences in relation to beavers if the licensed activity will be detrimental to beavers being maintained at favourable conservation status. I believe this is proportionate. It ensures that animal welfare considerations are taken into account while allowing a range of interventions to be carried out where necessary. And I'd also like to remind members that beavers only became a European protected species in May last year. Our beaver mitigation strategy is still evolving, and we will continue to refine it as we learn more about these animals and how they interact with their environment. And on that note, I'm happy to assure members that Scottish Natural Heritage are working very closely with stakeholders to address potential beaver conflicts. For example, they're working with farmers to trial new and innovative measures for reducing the impact of beavers, which should help to reduce the need for control measures of this type on this type of ground. Now, I mentioned that these licensing arrangements have been in place for only 1 year, so we have to give those measures time to bed in, rather than rushing to make further legislative changes, which could have very significant consequences and which Parliament has not had sufficient time to fully scrutinise. Presiding Officer, I hope to see the beaver population start to expand away from high conflict areas and into suitable habitats where beavers can thrive, and we will all see the positive benefits that these remarkable eco-engineers can bring. But I think we also need to remember that no one wanted to be in this situation where licences to control beavers would need to be issued. And as Murdo Fraser talked about in his contribution, it was the unsanctioned release of a colony into prime agricultural land in Tayside that has brought about these conflicts, which this government is now seeking to manage sensibly and with consultation. Presiding Officer, not only are these amendments unnecessary, they have the potential to be detrimental to the future of beaver colonies in Scotland. This amendment is ill-considered and could be detrimental to animal welfare in Scotland, and that's why I cannot support Amendment 56 or 56A, and Mark Ruskell should withdraw them.
Thank you very much. And I call on Alison Johnson to wind up in this group.
Thank you, Presiding Officer. I'd like to begin my closing by thanking colleagues across the Chamber who share my passion for animal welfare and for protection of Scotland's mountain hares. It's invaluable and it's appreciated. I think we have spent quite a bit of time in this in debate, particularly Mr Rumbles, Mr Stevenson and Mr Kerr focused very much on process, a process that I note did not concern them when it came to voting on an earlier amendment, and I regret that very much. It's either a principle or it is not. I will not, Mr Rumbles. Presiding Officer, animal welfare is a public good, and decreasing violence against animals is beneficial to society, as we've heard in earlier discussion in the Chamber today. And currently, mountain hares are protected in the close season between the 1st of March and the 31st of July each year. Yet there is increasing concern both about their population status and their welfare. In 2014, Scottish Natural Heritage, Scottish Land and Estates and the Game and Wildlife Conservation Trust issued a statement calling for voluntary restraint on large-scale hare culls. Now, since then, analysis of game bag data from SNH suggests that an average 26,000 hares are killed annually, and calls for action, not surprisingly, have increased. Now, my amendment has been supported by the RSPB, by the Scottish Wildlife Trust, by One Kind, by Revive and by the League Against Cruel Sports. And the Scottish public strongly support mountain hare protection. Almost 10,000 people responded to my members' bill, which included this very provision, and 74% of those respondents were supportive. I thank them all for their determination to see this much-needed change in the law. The mountain hare is the UK's only native hare, and it was listed as near threatened in a recent review by the Mammal Society. And the late Dr. Adam Watson said, he was one of Scotland's great ecologists, and he counted mountain hares across the moors and high tops of the Eastern Highlands for decades, since 1943. And he said, having counted mountain hares across the moors and high tops of the Eastern Highlands, I find the decline in numbers of these beautiful animals both compelling and of great concern. We need the Scottish Government and Scottish Natural Heritage to take action to help these iconic mammals off the hill. I hope they will listen to the voice of scientific research. And Professor Jeremy Wilson, RSPB's Head of Conservation Science in Scotland, who assisted in analysis of the data, said, "It's been an honour to support Dr. Watson in the analysis of his extraordinary long-term data set. These data reveal severe recent declines on grouse moors that are strongly correlated with the start of mountain hare culls for which there is no clear scientific justification. Urgent action is needed if the future conservation status of mountain hare is to be secure." Presiding Officer, mountain hares are being culled based upon no real evidence of benefit to grouse populations, especially where deer and other tick-host species, including grouse, are present. So it could be described largely as a precautionary response to promote grouse numbers by sporting estates. Let us ensure that we adopt a real precautionary measure, a real precautionary principle, and that we do not continue to allow the ongoing mass killing of Scotland's mountain hares. I wholeheartedly endorse the arguments of my colleague Mark Ruskell, who's campaigned with great commitment for better protection of beavers who have suffered in recent times. I will draw my conclusions. I will draw my remarks to conclusion, Presiding Officer, and I warmly urge my colleagues across this chamber to vote for this important amendment to better protect Scotland's mountain hares. Thank you.
Thank you very much, Ms Johnson. And we're going to go straight to the question. The question is that Amendment 30 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division. This will be a 1-minute division on Amendment 30. Members may cast their votes now. The result of the vote on amendment number 30 in the name of Alison Johnson is yes 60, no 19. There were no abstentions. The amendment is therefore agreed. Can I call amendment 56 in the name of Mark Ruskell? Mark Ruskell to move.
I'll move, yeah.
That is moved. The question is that, sorry, I call amendment 56E, Mark Ruskell to move.
I'll move that as well, yeah.
So the question is that amendment 56A be agreed. Are we agreed? No. We're not agreed. We'll move to a division on amendment 56A. Members to vote now. The result of the vote on amendment number 56A in the name of Mark Ruskell is yes 20, no 60. There were no abstentions. The amendment is therefore not agreed. Mark Ruskell wishes to press amendments 56?
Moved.
Yes, indeed. The question is that amendment 56 be agreed to. Are we agreed? No. We're not agreed. We move to a vote on amendment 56. Members, may vote now. The result of the vote on amendment number 56 in the name of Mark Ruskell is yes 20, no 60. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 62? This was debated earlier in the section on information sharing. Colin Smith to move or not move?
Move.
That is moved. The question is that amendment 62 be agreed to. Are we agreed? No. We're not agreed. We'll move to a vote on amendment 62. Members may vote now. The result of the vote on amendment number 62 in the name of Colin Smith is yes 41, no 37. There were no abstentions. The amendment is therefore agreed. I call amendment 63 in the name of Maurice Golden. This was debated earlier in the section on disqualification orders. Maurice Golden to move or not move?
Moved.
That is moved. The question is that amendment 63 be agreed to. Are we agreed? Yes. We are agreed. Can I call amendment 31 in the name of the Minister? This was under conservation and protection of marine life. Minister to move.
Moved.
Thank you. The question is that amendment 31 be agreed to. Are we all agreed? Yes. We are agreed. That ends consideration of amendments. Now, before we move on, members will be aware at this point of proceedings and required understanding orders to decide whether or not any provision of the bill relates to a protected subject matter, that is, whether it alters the franchise for Scottish parliamentary elections. In the case of this bill, it does no such thing. Therefore, it does not require a supermajority to be passed at stage 3. We're going to move on shortly. There's be a very short pause before we move on to the debate on stage 3. A very short pause. A short pause for the front benchers too. In fact, I'll just suspend shortly. A very short suspension.
Ask members to take your seats, please. The next item of business is a debate on motion 22-044 in the name of Marie Goujon on the Animals and Wildlife Penalties, Protections and Powers Scotland Bill. I invite those members who wish to speak to press the request to speak buttons, and I call on Marie Goujon to speak to and move the motion. Minister.
Thank you, Presiding Officer. I'm absolutely delighted to present the Animals and Wildlife Penalties, Protections and Powers Scotland Bill to the Chamber for the Stage 3 debate, because protecting Scotland's animal is an issue I'm passionate about, as I know many other members, as we've seen from the debate this afternoon, are right across this Chamber. And I think I can definitely say that we've given this a thorough scrutiny right throughout the whole process, and again, as we've seen from the debate of the last series of amendments there. But I think one thing that I've been keen to, and I suppose what I want to use that my opening contribution to discuss, is some of the other measures that have been introduced in the bill that I think that the debate has tended to focus on some of just the last few amendments that we've debated. But I don't want us to lose sight of or forget about some of the other really groundbreaking things that this bill is introducing. And again, that's why I want to focus on some of that in my contribution. So the bill increases the maximum available penalties for the worst animal cruelty and wildlife offences to allow courts to impose appropriate sentences depending on the circumstances of each case. And this follows growing public concern about the truly horrific nature of some of the crimes against wild and domestic animals that are reported. Now, these are thankfully rare, but they rightly attract a great deal of concern when the maximum penalties that can be imposed sometimes don't seem to be adequate when you consider the sickening behaviour that can be involved. The ability to try serious wildlife and animal welfare offences, either by summary proceedings or indictment, provides the courts with much greater flexibility in the range of penalties that are available to them. So this will allow a court to take full account of all the facts of a case and the penalties awarded to more closely reflect the nature and impact of any specific offence. And a very welcome and helpful aspect for enforcement agencies of this increase in maximum penalty to 5 years imprisonment and the availability of trial by indictment is that the 6 months time limit to investigate offences will be removed. Now, this will be a great benefit to the enforcement agencies and the Crown Office and Procurator Fiscal Service, because in many cases it can be difficult for them to be able to gather all the relevant evidence and complete the detailed forensic investigations that are often needed to secure a conviction within that timescale. Another improvement that will be welcomed by enforcement agencies is the power to put in place future fixed penalty notice regimes for animal health, animal welfare and wildlife crimes. Now, this will facilitate the development of more modern, proportionate and efficient ways of encouraging compliance with future regulations. And these will mostly be technical in nature and applicable where offences do not involve serious harm to animals, but where regulations may benefit animal health, welfare or wildlife protection overall. This important additional enforcement tool is widely welcomed by local authorities and the Scottish SPCA for its potential flexibility, proportionality and efficiency. This bill also improves protections for police dogs and horses, introducing Finns law in Scotland, recognising the important role they play in protecting us in sometimes very difficult circumstances. And I know that this is something that has been an issue that matters to quite a few people in this chamber. I'm sure I'll hear more about that. Now, I had the pleasure to meet Finn and his handler Dave, as well as colleagues in Police Scotland, and have been touched by their support for the measures proposed in the bill. By removing a potential legal defence for an attacker, this will provide police animals with equivalent protection to other animals that are not routinely used in dangerous situations to apprehend a suspect or control a crowd. Alongside that, the increase in the maximum penalties available means that all of Scotland's animals will benefit equally. Now, one of the most strongly welcomed parts of the bill for animal welfare enforcement agencies will be those provisions on emergency arrangements for animals that have been taken into possession to protect their welfare. Now, the SSPCA, who I've worked closely with on this bill, have described this as a transformative measure that should allow them in future to quickly rehome animals that they have taken into their care, rather than having to keep them for months on end waiting for the outcome of a court case. The bill will therefore deliver meaningful changes to assist these dedicated enforcement staff without placing new obligations or financial burdens on them. And with the amendment agreed today, the bill also now improves the welfare of seals, restricting the reasons industries can receive licences to lawfully shoot seals and raising the penalties for those who do so unlawfully without a licence. Yes.
Jamie Gray.
Thank you. I appreciate it's been a very long day, and I intentionally didn't participate in the negotiations at the stage 3, but there were 2 points I did want to put on record that are very important. And one is that, given the issue on seal culling, will the Minister provide appropriate guidance to the aquaculture industry so that they know what options are available to them in the event that a seal breaches a net in a fish farm? Because this is a real issue, and I know a number of them are now unsure as to what mechanisms are available to them in that scenario. So I hope that you will follow that up. And the second is on the issue of the mountain hare amendment that passed. If down the line we discover that there are unintended negative consequences that fly in the face of the well-meaning intention of the amendment, will the Minister have the resolve to come back to Parliament and amend the legislation at a future date if it is necessary?
Minister, and can I ask you to wind up?
Oh, yes, I'll try and be as brief as I possibly can. I just want to reiterate, I mean, while the amendment with seals, we did try to give as much notice to committee as we possibly could with that. This is something where we have been engaging with industry throughout this process. So I just want to assure the member that that engagement will continue so that we can work through any of these issues. And in relation to the amendment that's been passed on here, I mean, that's why I stated at the end of my comments that this was going to be something that we are going to have to closely monitor. We want to make sure that we do the consultation because this will have an impact. So we've got to make sure we know what that impact might be. We've got to work with SNH because obviously it's something that's going to have an impact on them. So this is something that we want to be able to do that groundwork and consult properly before, as we develop a licensing regime and before that protection comes into force. So I just want to give that assurance. We want to make sure all that work is done. And like anything, I mean, we've seen the debate on beavers. This is something that we've got to monitor very closely because we've got to monitor the measures that we've now brought in, that we hopefully, if the bill is passed today, that we'll be bringing into force. And just to conclude, I realise that we are under a time pressure now. I would say that all the measures that I've outlined today, this is just the start of the process, and this doesn't mean that the work stops, because there is a whole programme of future work that we have planned in relation to licensing, to consult on animal transport improvements, and to continue our successful publicity campaign and collaborative working on illegal puppy dealing. So again, there are lots of important issues when it comes to animal welfare, and this is very much the start of that process. So with that, I move that the Parliament agrees to pass the Animals and Wildlife Penalties, Protections and Powers Scotland Bill.
Thank you very much, Minister. And I call Finlay Carson, 5 minutes.
Thank you, Deputy Presiding Officer. Let me say from the outset, the Scottish Conservatives have been supportive of the general principles of this bill at stage 1, at stage 2 and indeed at all stages, which was to update the Animal and Welfare Act 2006. Because after a decade of experiencing and enforcing the Act, it was clear that some aspects of the penalties applicable under the Act should be updated. We've also been supportive of most of the provisions that we now see in the bill after Stage 3 amendments, with the overall objective which increases the range of sentencing options in relation to animal welfare and wildlife offences. We fully support the provision of more stringent sentencing powers, which will send a strong and clear message that wildlife and animal cruelty is totally unacceptable. There are, however, several amendments we could not support, and particularly those introduced at Stage 3 that have not been subject to the normal scrutiny and examination that we would get at Stage 2. Not going through the committee process, where there's no good reason, only increases the potential for poorly drafted and bad law, and I fear that that might happen, particularly with the hare amendment. It's very disappointing, but not surprising to see the Greens once again, in my opinion, abuse the flexibility within the parliamentary process to bring in at the last-minute amendments, which I believe were outside the original scope of the bill as we as our committee understood, and we were told that the bill wouldn't cover from its outset. Not only does it bring good lawmaking process into question, it's disrespectful to the committee process, which I would think, and with particular reference to my own committee, the Eclair Committee, I know I and my fellow members pride ourselves in the evidence-based way we look at legislation in a sensible and generally non-party political way. But there's only one reason for the Greens doing this. It's for grandstanding, the worst type of virtue signalling, which they fail to recognise that their method actually puts at risk the bill proceedings. We have so much good law in this bill, and inserting the last-minute controversial amendment put the whole thing at risk. It's counterproductive, can actually stop potentially good legislation, which the Greens could bring forward. In this case, putting at risk hugely important topic of animal and wildlife offences. Throughout the process, we've been supportive of fixed notice penalties, which the Minister touched on, which are now part of the bill, giving authorities a greater degree of flexibility in determining penalties. We do need to ensure People face the consequences of their criminality, and we need to see an improvement in the disparity between the number of fixed notice penalties and how many remain unpaid. But once again, this is an area that was previously raised surrounding concerns and the use of fixed notice penalties, was how that information was held and shared between the relevant authorities. Currently, there's no central register to hold the information, and the committee recognised that there was the need for that more joined-up thinking when it came to intelligence sharing. It's clear that animal welfare crimes are also linked with other crimes, so I therefore welcome Colin Smith's amendment to ensure that there is a report to make sure we use the best use of the data to provide valuable information to the public, stakeholders and the Parliament on animal and welfare crimes. Having access to identify convicted offenders is a vitally important part of this bill, but it must be done in the right way. I've got very little time, but I must welcome one particular excellent piece of the bill, and that I welcome Maurice Golden's amendment on the review of additional animal fences, which will include relooking at electric dog collars, which this government has unfortunately failed to ban. And finally, my colleague Liam Kerr has done terrific work to ensure that Finn's law to protect police dogs and horses who serve alongside our officers, which was already introduced in England and Wales, will now be extended to Scotland. Presiding Officer, this bill is long overdue to ensure that those who continue to commit painful and cruel crimes against animals now know that they will be dealt with the full force of the law. And it's welcome to see the Scottish Government deliver on their commitment to deliver this, to ensure all parts of the United Kingdom have legislation cracking down on wildlife crime.
Thank you very much, Mr Carson. And I now call Claudia Beamish up to 4 minutes.
Thank you, Presiding Officer. This is indeed an important bill, and it is right that penalties and powers related to those offences in the bill are brought in line with a more modern understanding of their severity. Scottish Labour understands that all animals are sentient. It also understands that we're in the midst of an environmental emergency. The government's record on biodiversity is not that strong, with 1 in 11 Scottish species threatened with extinction, and there's a serious need for a plan for an accelerated action after 2020. With these 2 points in mind, my colleague Colin Smith and myself have worked hard to reinforce legislation to make the bill even more meaningful than when it first came to our committee. My sincere thanks go to One Kind, RSPB, Open Seas, Sustainable Inshore Fisheries Trust and Scottish Badgers for their input into this bill in helping us with our amendments, and of course others as well. I'm relieved that the nesting and resting places have been passed, and the devastation of these shelters being destroyed or damaged has been well documented in this bill process, and the harm done can be equivalent to a direct attack and just as fatal. I'm disappointed that my amendment on marine protected areas has not been passed today. To simply base the penalties on the value of the fish caught misses the point of the untold ecosystem damage and damage to habitats and to specific wildlife species, marine species that can be done. These are wildlife offences just as they would be on land, where it's much easier for people to take notice. So it is disappointing, as I say. However, I do welcome Alison Johnson's mountain hare protection as one of the amendments in this bill, which was passed quite surprisingly, but long overdue. And I also am very pleased that the vicarious liability amendment that I had support from the Minister on the illegal traps and snares was passed, although disappointed again that after many suspected incursions with raptors that have occurred in my region and other issues that I was keenly aware of in relation to a small number of landowners and managers, that the other amendments were not supported. I want to highlight very briefly the extension possibility of SSPCA powers of investigation, an issue which has been live since the last session of the Scottish Parliament in the then Raki Committee, which I was a member. It surely cannot be right that officers can deal with a live animal caught in a trap, but not a nearby trap with a dead one in it. And wildlife crime, as we know, can often happen in remote and isolated parts of Scotland. It makes sense that I hope the Minister is going to further investigate these possibilities, including any possible conflict of interest or governance arrangements implications. And the expertise of the SSPCA would be welcome a welcome addition in tackling such crimes in the context of constrained police resources and, again, remoteness. Finally, I look at the programme requirements for restorative and rehabilitative processes and approaches to less serious animal and wildlife crimes, and I'm very pleased that the Minister is going to be taking forward and quickly commissioning the research on this. And as I draw to a close, my friend and colleague Colin Smith will highlight some of his amendments that have passed in closing for Scottish Labour. The protection of animals and wildlife is something that people in Scotland feel rightly impassioned about, and I have sought to listen to those voices and to strengthen and reinforce the bill accordingly. Scottish Labour will be supporting the bill today. Thank you.
Thank you very much. And I call Mark Ruskell up to 3 minutes. Mr. Ruskell.
Thank you, Deputy Presiding Officer. Of course, the Greens will be backing this bill tonight. And I think the Minister makes an important point, which is that we shouldn't lose sight of the important provisions that are in the bill, particularly increasing maximum sentences, fixed penalty notices, disqualifications of owning animals, Finn's law. These are all important provisions. But there has been a missed opportunity to bring forward a full reform of the 2006 Animal Welfare Act. And I think the late amendments on seal culling are perhaps the clearest example of where if the bill had been introduced with a much broader scope, it would have been able to fully address a much wider range of outstanding animal welfare and wildlife issues. And I think what we've seen this afternoon is actually members from across all the parties in this chamber, apart from the Liberal Democrats, introduce amendments which have effectively broadened the scope of the bill that was initially introduced. And as a Parliament, if it had been broader, we would have been able to properly scrutinise seal culling, the related issue of ADDs, and many more issues that have had a brief airing today. But looking forward, I hope that the next Animal Welfare and Wildlife Bill will come soon, and that we'll not have to wait years and years for government to move on issues such as the extension of the powers of the SSPCA or outlawing electric shock collars. The timeline on extending SSPCA powers so they can investigate wildlife crime has thus far been a farce in this Parliament, Minister. And while I welcome the commitment given by you to set up an independent review body, I would ask the Minister to show real leadership on this issue, because up to now, we've had 6 Environment Ministers over the last 9 years who have announced consultations, reviews, delays, and alternative ways forward like special constables that have manifestly failed. And every time we go around this cycle, we come back to the same conclusion, that wildlife crime is rife, that the police are overstretched, and that the role of the SSPCA needs to be extended. Now, the Greens have placed considerable faith in the Minister to deliver on this. The SSPCA powers could have been included in this bill, but they weren't, and I did not move any further amendments at stage 3. We've accepted the independent review, but this has to have a firm timescale for delivery. An upfront government commitment to extend the powers must be the starting point for the review. And I'd like to hear a timescale from the Minister in closing, not just for reporting of this review, but for enacting its long overdue recommendations. Presiding Officer, many of those working at the front line of tackling wildlife crime and upholding the rights of animals will warmly welcome the passing of this bill. But there is still so much more to do, and many crimes that will still go undetected and unprosecuted. Traditions must be challenged by evidence, and decisive action and legislation is still needed to restore our relationship with the natural world. And I look forward to this Parliament delivering that agenda in the years to come.
Thank you very much. I now call Liam MacArthur for a remote contribution up to 3 minutes. Liam MacArthur.
Thank you, Deputy Presiding Officer. It's been a long afternoon, and some of us have probably exceeded our screen time for the week, and it's only Wednesday, so I will be brief. Scottish Liberal Democrats warmly welcome the passing of this bill. I commend the Minister and her officials for steering this legislation through, those who have given evidence throughout the process, and of course to the Clare Committee members for their valuable scrutiny work. Of course, the committee can only scrutinise what it has in front of it, and here again I would question the approach taken by the Green. Stage 3 is, and always has been, an opportunity to tidy up a bill, not a point at which new proposals are parachuted in, backed by email campaigns. That is not a substitute for evidence gathering and robust scrutiny. All that said, Scottish Liberal Democrats do strongly back the aims and the provisions of this bill. At the outset, we were reminded by a number of witnesses that Scotland currently has one of the lowest sentences and penalties for animal cruelty anywhere in Europe. As I said at the Stage 1 debate, 12 months in prison and a fine and a ban on keeping animals for the worst act of animal cruelty compares poorly with up to 5 years imprisonment for fly tipping. That is a comparison that does not reflect well on our justice system, does not reflect public attitudes towards crimes of animal and wildlife cruelty, and as such was in need of reform. By increasing the maximum available penalties for cruelty and causing unnecessary suffering to both wild and domestic animals, this bill helps to address this, thanks in no small part to some of the amendments passed earlier this afternoon. Broadening the range of prosecutorial options available, as the Law Society has made clear, is helpful. It also has the effect of potentially increasing police powers in the detection of more serious crimes. It is to be hoped, however, that the measures in this bill act more as an effective deterrent. It is in all our interest to see a reduction in cases rather than an increase in prison populations. In that context, I commend Claudia Beamish for the work that she's done in pursuing alternative approaches around restorative justice. Not only does this have the potential to be more effective in reducing reoffending, it can also help avoid compounding the serious problem of prison overcrowding in Scotland. Claudia Beamish also led much of the efforts to extend the use of vicarious liability, while ultimately this has only been expanded to include a small number of practices, including illegal trapping and snaring. I think this represents an important step forward, hopefully a way of deterrence. Finally, Deputy Presiding Officer, let me congratulate Alison Johnson again on her successful amendment on mountain hares. I stand by my earlier comments about the Greens' cavalier approach to parliamentary scrutiny, and there is much work to do to make these proposals workable in practice. On a personal level, however, I acknowledge and respect the work that Alison Johnson has put in on this issue over a prolonged period. Deputy Presiding Officer, this bill enjoys overwhelming public support and will help address a number of long-standing shortcomings in the way that animal welfare and cruelty are treated under our legal system. As with the Wildlife and Natural Environment Act in 2011, however, it's almost certainly just the latest step to be followed by others in due course. For now, however, Scottish Liberal Democrats welcome and strongly support the passing of the Animals and Wildlife Penalties, Protections and Powers Scotland Bill. Thank you.
Thank you very much. And I call our one open debate speaker, Gillian Martin, up to 3 minutes, and I'm afraid I'll have to hold you to that.
Yeah, clock starts now. Like the Minister has, I want to concentrate on the initial policy outcomes of the bill, which is to increase penalties for abuses against animals. And I just want to put my ECCLR committee hat on and mention the vital role of our committee in scrutinising policy and teasing out all the consequences of that policy. I'm not going to say any more than that. Other people have said about what's in front of us. We've scrutinised it well, and we had some quite incredible evidence on the need for increased penalties, including the potential for increased custodial sentences for the most heinous crimes against animals. And that evidence prompted the committee to push the government to make changes to the bill, including criminalising the willful destruction of animal habitats, which in many cases is tantamount to killing them, the power of the SSPCA to investigate a case where an animal is found dead as a result of suspected cruelty, and better intelligence sharing between law enforcement and the SSPCA. I want to thank the Minister for her receptiveness, not only to our committee recommendations, but to the many amendments lodged at stage 2. She's worked with members, and it's to her credit. I think she's done an outstanding job. One of the most important parts of this legislation for me is the ability to quickly and permanently rehome animals seized as part of a police investigation. This is something I've called for a long time with my colleagues at the SSPCA, and I've spoken before about the devastating situation in Fyvie in my constituency, where hundreds of bitches and pups were illegally kept in appalling conditions, and many of you will have seen the BBC Scotland documentary where this featured. Shocking pictures of burned bodies of puppies in a burnt-out car will never leave me. And the prosecution of those responsible at that time sadly could not include a significantly proportionate custodial sentence, and the surviving animals involved were cared for by the SSPCA in shelters for the 2 years, nearly 2 years it took for the animal abuser who bred them to be sentenced, as he time and again attempted to frustrate the legal process. And of course, many of the animals had to be put to sleep as they were in such poor health. This bill rectifies all of this and sends a strong signal. The time is up for animal abusers like Frank James in Scotland. Presiding Officer, while I've still got a few seconds left, I finally just have to say, as the Grey Seal champion, it might have been last minute, but as the champion, I'm delighted that they can't shoot seals anymore. When I grew up in Newborough, they hardly saw any. But now, because they're not shot anymore, we've got a hall-out site filled with thousands of them, and we're becoming quite famous for it. Presiding Officer.
Thank you very much. We now move to closing speeches. Colin Smith, up to 3 minutes, please.
Thank you, Presiding Officer. Scotland currently has some of the lowest penalties in Europe for animal welfare and wildlife crimes. This bill is an important step towards addressing this, giving our courts the powers to make sure the penalty fits the crime. It sends a clear message that we take these issues seriously, that we recognise the sentience and value of animals, and we will not tolerate animal cruelty and wildlife crime. So I want to pay tribute to those animal welfare organisations for their hard work in campaigning on these issues. Battersea Cats and Dogs Home for the campaign in Finlaws and 5-year maximum sentence, a campaign that the Dogs Trust, Blue Cross, Edinburgh Dog and Cat Home, PDSA and Cats Protection were also instrumental in championing. Environment Link for campaigning for higher penalties for wildlife crime and in support of extending this to resting places and raising the issue of vicarious liability. RSPB and their calls for higher wildlife penalties, one kind for their work on so many issues, from rehabilitative sentence, disqualification orders, information sharing, to name but a few, and their revived coalition partners for helping end the mass cull of mountain hares, and Scottish Badgers for their support and help with my amendments on badger sets. Thank you to you all for giving our animals a voice. Since this bill was introduced, those organisations and cross-party cooperation has ensured this bill has been strengthened, including a number of important amendments passed today. I'm delighted my amendment strengthening the penalties for disrupting a badger set, increasing the maximum penalties available for offences created by regulation. The changes made to disqualification orders and information sharing were all agreed today. I'm also absolutely delighted that Alison Johnson's amendment making mountain hares a protected species was also agreed. The ongoing culling of mountain hares and the growing risk of local extinction is shameful, and proper protection is a long overdue step forward. And, Presiding Officer, on many issues, this bill, welcome and important as it is just a step forward in a long journey to end the scandal, the waste, the immorality of animal cruelty that still plagues and shames Scotland. There is, of course, much more I would have liked to have seen agreed in this bill. I'm impatient for an end to animal cruelty, an end to the use of snares, an end to the cruelty of greyhound racing, an end to hunting with dogs, an end to live animal exports, an end to tail docking, and also better protection to cephalopods and decapod crustacean. Presiding Officer, I want to make a special mention of Mark, who's in Primary 7 at Sunnyside Primary, for this wonderful poster he drew on World Ocean Day, calling on us to see the suffering of our sea creatures. Now, we may not have delivered that extra protection today, but I hope that commitment the government gave to consider the research on this issue further will lead us to doing so one day. So my message to Mark, my message to everyone who wants to see an end to animal cruelty is to keep up that campaign. Take pride in this bill, which is a step forward, and come back tomorrow to redouble your efforts for the long journey ahead. Thank you.
Thank you very much. And I now call Rachel Hamilton. Up to 3 minutes, please.
Thank you, Presiding Officer. In closing today for the Scottish Conservatives, I'd like to express my thanks to the Eclair Committee for their work on this bill. On these benches, we fully support tougher sentencing for animal cruelty. Undoubtedly, the most serious cases of cruelty should be dealt with more severely. I also want to thank members for their thoughtful contributions. However, I must take this opportunity to call out the puddle-headed amendments put forward by the Greens at stage 3. On the subject of manuscript amendments today, they have proved neither elegant or satisfactory for those of us who believe in proper scrutiny. The Greens to bring forward manuscript amendments forward at the 11th hour was counterproductive and has not given justice to the importance of the bill we are debating. This landmark bill was nearly derailed as a result of their ill-conceived amendments, which lacked solid scientific evidence and stakeholder consultation. The Scottish Conservatives received a huge amount of correspondence on Alison Johnson's stage 3 amendments on mountain hares, stating that they are significantly flawed and lacked scrutiny. Many pointed out that Ms Johnson did not mention that her amendment will create unintended consequences for other conservation-listed birds. The Greens ploughed on regardless with their shameful virtue signalling, trying to implement bad law, which does not reflect the actual situation out on Scotland's hills and mountains, choosing to ignore scientific facts or taking the time to consider a balanced approach. Now the Scottish Government are ignoring their own Werity report, ignoring the James Hutton Institute, SNH and the Game and Wildlife Conservation Trust, and have been strong-armed into joining the virtual signalling. The rural heartlands will remember this. Once again, we see a city-centric government ignoring rural communities and doing dirty backroom deals with the Greens. From the outset, the Scottish Conservatives have worked with other parties to ensure the fines and penalties for the worst animal cruelty offences are increased. On empathy training, I thank Claudia Beamish for her work on this and welcome the announcement of the Scottish Government Restorative Justice Programme. I hope that this work will include research to link domestic abuse and animal cruelty. There are other parts of the bill that actually were positive. It goes without saying that Liam Kerr should be thanked for bringing forward Finn's Law. I was pleased to see Maurice Golden's amendment passed to encourage the proper use of disqualification orders supported by all parties. Reckless destruction of badger sets is not acceptable, and the Scottish Conservatives were happy to support increasing maximum sentences and fines for offences against badgers. Furthermore, the Scottish Conservatives are pleased that census prevailed over vicarious liability, which would have punished responsible landowners and others for crimes they did not commit or had no knowledge of. The Scottish Conservatives were content to support maximum penalties to provide courts with the necessary tools to deal with such heinous offences, including those who recklessly destroy wild habitats and the collection and trade of rare bird eggs, and thank Claudia Beamish and Angus MacDonald for bringing forward those amendments. Personally, I was disappointed there were technical issues with the amendment regarding illegal pesticides and would ask that the Scottish Government consider calling for a further amnesty to deal specifically with this issue. In conclusion, Presiding Officer, overall, the Scottish Conservatives support this bill, but were deeply disappointed by the actions of the Green Party.
Thank you very much. And can I call our final speaker in this debate, Minister Mary Gouchon, up to 4 minutes, please.
Thank you very much, Presiding Officer. But I think one thing's clear, and that if anything can be taken from the debate today, I think it's the passion and strength of feeling that members across the chamber have regarding animal welfare and our wildlife, as well as the seriousness in which they treat these issues, and not just here in Parliament, but more widely in Scotland. And I really am proud to be introducing this important piece of legislation to strengthen and modernise the enforcement of our world-leading legislation, because I truly believe that we have, and indeed expect, some of the best animal welfare standards in the world. And this important and focused bill will have real impacts on the ground as soon as it comes into force. And when it becomes law, the bill will send an even stronger message that animal cruelty and wildlife crime of any kind will not be tolerated in Scotland. And I think Gillian Martin gave a very good illustration of that with some of the cases that she highlighted. Now, it will provide much greater flexibility for the authorities to deal with a wide range of offences, and it will protect the vulnerable people and animals involved in these often troubling animal welfare situations, reducing the burden on courts, enforcement authorities, police and farmers. And the bill is welcomed by stakeholders with strong support from the public, and I hope that the provisions will lead to behaviour changes which further reduce animal cruelty and wildlife crime. Now, right from the outset of this process, I wanted to engage with members across the chamber so that we could develop a strong piece of legislation with the welfare of our animals and wildlife at its heart. And this was always above politics as far as I was concerned. And I would thank Gillian Martin for her kind comments about that. Now, I know that there are areas where we haven't always been able to agree, but I don't doubt for 1 second that every single one of us involved in this process has had the improvement of animal welfare as their main motivation. But saying that, there have been many areas where we have come to a resolution based on the work that we've done with committee and with other members, again, across the chamber. So whether that's been in relation to increasing the penalties for the destruction of sets and habitats, so with that consensus, we've been able to move quite a long way. There's elements of vicarious liability that we've looked at and considered and been able to find a solution to. So clearly, there is a very strong will across all the parties to make the significant improvements to animal protection that this bill will deliver, and really to give our frontline enforcement bodies the legal framework that they've been asking for and that they need to be able to do their job most effectively. Just to cover a few of the points briefly while I can that I know have been raised in the debate. I mean, Colin Smith, you spoke about cephalopods and decapods. Now I've committed to considering new evidence in relation to a recent PQ, and have also written to the Environment Committee to confirm that I will carefully consider the results of a research review that will shortly be commissioned by DEFRA when these are available, and if appropriate, the extension of protection can be achieved by secondary legislation using an existing provision of the 2006 Act. Another element that was raised in the contributions here today was about the Scottish SPCA. It was raised by Claudia Beamish and Mark Ruskell. Now, there was a lot of discussion going through the committee evidence sessions and at each stage of the bill regarding powers for the SSPCA, but I do genuinely believe we've taken the right approach here by establishing a task force that will fully consider this and the issues around it, and what any potential implications of what any proposed changes to those powers might be. And I know that the Scottish SPCA fully support that approach. I know that Mark Ruskell was saying that the starting point needed to be that we'd give an upfront commitment to give those powers, but that would really preempt that work. So that's why we've got to make sure we do that as fully as possible. Now, in drawing to a close today, I know that during the course of the debate, there have been a lot of hotly contested issues and strong debate. And again, that just goes to show how passionate we all are about our animals and wildlife in Scotland. And again, while there have been areas of disagreement, I don't want us to lose sight of where we have all agreed and all the many positives we're achieving through this bill and the massive strides we've made in improving the welfare of our animals and wildlife. We now have a full suite of penalties open to animal welfare, animal health and wildlife offences. We've increased the penalties for the worst and most serious cases of animal cruelty and wildlife crime. And we've got the ability to thoroughly and better investigate that crime. And we're giving increased protection to our service animals through the introduction of Finn's Law. And let's not forget the truly transformative change when it comes to the ability of our enforcement authorities to rehome and care for animals taken into their care. And that's an area that will have an immediate, and I repeat, truly transformative change. I want to thank those across the Chamber who've engaged with me in this and trying to make these improvements, and to the Environment Committee for their detailed work and scrutiny. But again, also I want to give my thanks to those working on the front line in this, the Scottish SPCA amongst many others, who are so passionate about what they do and who have worked closely alongside us during this process, and who day in, day out, and particularly during this current crisis, are working to care for and protect Scotland's animals. So thank you. And with that, I hope that members will join me in supporting this bill today.
Thank you very much, Minister. That concludes the debate on the Animals and Wildlife Penalties Protection and Powers Scotland Bill, and we will now move on to the next item of business. Thank you.
Thank you, colleagues. The next item of business is consideration of motion number 22045 in the name of Hamza Youssef on legislative consent motion domestic abuse bill. Could I call on Hamza Youssef on behalf of the Bureau to move this motion?
Move, Presiding Officer.
Thank you very much. And the next item is consideration of motion number 22046, also in the name of Hamza Youssef, on an LCM private international law implementation of agreements bill. Could I call on Mr Youssef to move this?
Move, Presiding Officer.
Thank you very much. The next item is consideration of business motion 22067 in the name of Graham Day on behalf of the Bureau setting out a business programme. Could I call on Graham Day to move this motion?
Move, Presiding Officer.
Thank you very much. And no member has indicated they wish to speak against the motion. Therefore, the question is that motion 22057 be agreed. Are we all agreed? Yes. We are agreed. The next item is consideration of 3 Parliamentary Bureau motions. Could I call on Graham Day on behalf of the Bureau to move motions 22054 on referral of SSIs, 22055 on approval of SSIs, and 22056 on suspension and variation of standing orders? Thank you. So we turn to decision time. The first question this evening is that motion 22044 in the name of Marie Goujon on the Animals and Wildlife Penalties Protection and Powers Scotland Bill at stage 3 be agreed. Members should cast their votes now. The result of the vote on motion 22044 in the name of Mary Goujon is yes 74. There were no votes against. There were no abstentions. The motion is agreed and the Animals and Wildlife Penalties, Protections and Powers Scotland Bill is passed. The next question is that motion 22045 in the name of Hamza Youssef on Domestic Abuse Bill UK legislation be agreed. Are we all agreed? Yes. We are. The next question is that motion 22046 in the name of Hamza Youssef on Private International Law UK legislation be agreed. Are we agreed? Yes. We are agreed. And I propose to ask a single question on the Parliamentary Bureau motions. Does any member object? The question, therefore, is that motions 22054 to 22056, inclusive, in the name of Graham Day, on behalf of the Bureau, be agreed. Are we all agreed? We are agreed. That concludes decision time, and I close this meeting.